That's serial number 54. It may be taken up after 2 weeks. Ma'am.
Pardon, which matter?
54 serial number.
March 19th.
That's serial number.
10 to 19 March as requested by learner. Petition.
Memo for withdrawal of the writ appeal.
Which one? Listed today? Tomorrow. Tomorrow at 2:30.
Lordships kindly state appeal for posting.
Mention.
Which matter, my lord?
What is the urgency? What is the urgency?
Custody has been taken from the Muthoot Finance Limited, my lord.
Custody of child.
Gold. Gold.
Custody of Gold. Gold. So it is appeal.
Writ appeal, my lord.
21st February. Earlier.
Day after tomorrow, my lord.
Day
31st.
after tomorrow. Then 4th of February.
Lord, state appeal, my lord. Matter relates to implementation of the 6th pay commission, my lord. They are requesting for retrospective implementation, my lord. There are batch of matters that are scheduled for the day, my lord. Earliest convenient date to lordship for hearing, my lord.
The matters are listed when?
Similar matters are scheduled today before the learned single judge, my lord, where the single judge is following the impugned judgment. Therefore, there is slight urgency, my lord. That is the only reason. Earliest possible date for lordship.
5th of February.
Grateful.
So we make a mention with regard to serial number 15 minutes.
15.
50 minutes.
IV.
That's I appear for the responding statements. And that's I've informed the petitioner, the matter may be taken up after 4 weeks.
For the appellant in the first matter.
It has both state appeals as well as the
4th
private.
4th March.
With
As
your
requested.
lordship's kind indulgence.
10 to 4th March as requested.
With your lordship's kind indulgence, my lords.
Office objections are there.
Serial number,
So-
We'll do the needful.
Full stop. Before the next date of posting, the office objections will be complied.
We'll do the needful.
with your lordship's kind indulgence, for serial number 18-1, my lord.
81,
18-1, 1-8.
18.
Please, Lord. Lord, it is a transferred brief for me, but it requires some more clarification in this case. Your lordship kindly call it after a week or 2 weeks. 18-1. 18-1, lords.
18,
18-1, that's my matter. Where it is a transfer brief.
18.1.
18-1, lords.
So let it, 18 will be considered, 18.1 will be considered.
I don't know, lords, because no, it is a transferred brief. Lord, still, I want some more clarification from my client. That's why I'm not, 1 week time may be granted.
Let us see when it is.
Oh, please, lords, please.
Any mention through VCs?
Permission.
Sir, contempt matter, seal number 1 to Naveen JN.
I appear for the complainant, Your Lordship. Lordship, the accused is the adjacent owner of the property, started construction, Lordship, in violation of sanction plan. I filed a writ petition and there was an order of status quo. Lordship, page 37, he filed an affidavit by way of undertaking that he will not put up any further construction, Your Lordship. Page 37, Your Lordship, paragraph 3 and 4. And he has given undertaking that he will leave the setback and he will further construct as per the license sanction plan. Lordship, page 39, in view of his undertaking, the writ petition was disposed of. Lordship, that was in the year 2022, and he kept quiet, my Lordship, for 2 years. And thereafter, in the month of April 2024, again he started the construction, Your Lordship, without leaving setback. I have given a representations to the BBMP. It is a clear violation, my Lordship, of his own undertaking before the learned single judge, Your Lordship.
Violation of what, undertaking or of court's order?
Violation of his undertaking, my Lordship, before the learned single judge.
Notice 3rd March.
Please.
Seal number 2 to Adi Narayanappa. Seal number 2.
Keep this.
Case number 3, Srimati Jyoti SK.
Notice. Take your time.
There is a delay in this because we have been following with the concerned authorities for
Notice. Take your seat.
following.
Don't worry. Take your seat. Notice returnable on 28th of February.
Shorter date. we
Shorter
are
date.
Trying to actually pass an order,
13th February.
handsome ones also are there.
Case number 4, Mr. Muniraja.
4. Notice returnable for March.
Okay, connected matters posted on 28/2.
28 to.
Right.
What is connected? All bodies are connected anyway, very well.
It's 58. Case number 5, Mr. Keshav M. Datta.
Notice returnable on 5th March.
Similar matters listed today, Madam. Same number 59 and 68.
So you want this to be taken up together or
Together, Madam.
keep back?
Great.
Case number 6, Mr. Subramania Bhatt. Case number 6,
Also keep back.
case number 7, Mr. Shiv Prasad Naik.
For complaint.
Pardon? Yes,
Contempt of petition of the state. This matter, my lordship. Regularization of the unauthorized cultivation.
notice returnable on 5th March.
Short date, Madam. Short date.
Case
5th
number-
March.
case number 8, Mr. Kalyan Basuraj.
Complaint.
Notice returnable. 4th March.
Case number 9, Mr. Satish K. Case number 9,
Pass over.
case number 10, Mr. Venugopal MS.
Notice 4th March.
Place.
Say PL matter, case number 11, Mr. J.R. Mohan.
Stated for petition. This writ petition is for a direction to the respondents to fix the road spots and to repair and maintain the road between Kamala and
I think pass over.
Torana village. This writ petition may kindly be disposed of with the direction to consider my
But
recommendation.
every day you bring this Kamala Nagar.
Yes, my lord.
You belong to, you're native.
No, the petitioners, yes, my lord.
Hospital in Kamala Nagar, road in Kamala Nagar, drinking facility in Kamala Nagar, power supply in Kamala Nagar,
Yes, my lord.
right?
He's a native of Kamala.
Shifting of office also earlier. Same?
Yes.
Or learned advocate Mr. So and so for the Mohan for the petitioner and learned additional government law for upon service of copy of the petition in advance.
Amended petition.
And this petition styled as public interest petition, the direction is paid for against the respondents. To fix the road spots. From a repair and maintain the road
Respondent number 5.
between Kamala Nagar and Torana villages of Kamala Nagar Taluka, Bidar district. In light of the representation of the petitioner dated 23/10/2024. It is the case of the petitioner that. Yes, for Kalyan. Yeah. Vacated. So in the facts and circumstances, no relief could be granted to the petitioner except requiring the competent authority respondents to take an appropriate decision in respect of the representation of the petitioner already pending, which has been undecided. In that way, the present petition is disposed of, without going into the merits, by directing the respondents to act through the competent authority and take a decision on the representation of petitioner, preferably within a period of 4 weeks, 6 weeks.
Beautiful, my lord.
This petition is disposed of in the office. They are awaiting tomorrow also some petition.
Yes. Number 12. Respondent.
Petitioner.
My lord, I apologize. My lord, in this, I seek for a short adjournment
This
till
Kamala.
Monday, my lord.
Yes, my lord.
Monday, Tuesday. My lord, the respondent number 5, who is before my lords. My lord, there is a government order. We haven't received the government order, my lord, to represent respondent number 5. Statement of objections are ready. My lord, if my lord could have it on Monday or Tuesday, my lord,
Used.
obliged.
Much.
My lords, can it be on Monday, my lord? Can it be on Monday, my lords, or on 6th? 4th and 5th, there's some difficulty, my lord. We're being led
6th.
by Mr.
6th.
Number 13.
Lords,
Writ of appeal
the
matters.
appellant in this
Honest
case, please,
market.
my lords. But this is a case, please, my lords, where a plan was, I've served the caveat of, please, my lords. The plan was sanctioned, the plan application was made to us, please, my lords, seeking for, my lords, an FAR of 2.25. When we went to the spot, please, my lord, the road width was less than about 11.8 meters. They were not entitled, please, my lords, for an FAR of 2.25. They were entitled, my lords, for an FAR of 1.75. Accordingly, please, my lords, we are ready and willing, my lords, to sanction the plan at 1.75. What they contend, please, my lords, they've shifted the compound. Only at the place, please, my lords, the writ petitioner's premises is situated. To show, please, my lord, that the width of the road, my lords, is 12.2 meters. That they have achieved only by shifting of the compound right in front of their premises, please, my lords. And all along the road, please, my lords, it is about 11.85 meters. So hence, my lords, we will not be in a position to give higher FAR. Next year, in page number 96, please, my lords, is the endorsement that we have issued, where we have clarified, please, my lords, that the road width is about 11 to 11.8.
The ultimate effect of the order of Law Single is to make the width of the road uniform, then there is no.
That will, let's take time, because these are all village areas, 110 villages, which has now come into the ambit of the BBMP. At this stage, please, my lords.
Difficult to decide such matter. Therefore, notice. Notice returnable on.
Look, there is caveat served.
Caveat is there.
Sir.
Then wait. Then wait. Pass it over.
Number 14. Mr. Sachin BS.
My writ petition was rejected, confirming the order of tribunal. Tribunal rejected my appeal on the ground of delay and laches. Yes, we are not party to that proceedings, and I have clearly explained the delay. I am also a claimant.
Where you explain the delay?
Yes,
You are not party.
I was, my lords, the grant order was challenged in an
You are
appeal.
here seeking leave to appeal.
I'm sorry, my lords, I have not enlightened my lords properly.
Here you are seeking leave to appeal.
Yes, I was not a party. The grant order, I'm sorry, sir.
Party before.
The grant order was challenged by an appellant before the tribunal. That is my claim. And my appeal was dismissed on the ground that it is, since the grant order is of 1994, you come before the court in the year 2015. Therefore, your appeal is barred by limitation is the finding recorded by the tribunal. Against that order, I preferred a writ petition. Single judge dismissed my writ petition confirming the order of the tribunal. My lords, my submission, limited submission before my lords is that, my lords, though there was a grant order, it was a paper order. The possession was with me. And there is a material to indicate that there is a, I'm sorry, sir, I'm sorry.
You are party before which, you are not, you are not party before.
I'm
which-
not a party.
Before which authority?
Before the revenue authority.
Oh, that is. So you are not a party.
I'm not a party. I am a rival claimant. My application for regularization of land is still pending consideration. When my application is pending, they have granted the land to my opponent. That grant order was called in question immediately after I came to know that when there was a threat of disposition
So grant order in whose favor?
in favor of my opponent. That is respondent number.
My lord, the grant is for an exchange.
I had certain lands, my lord. I gave it to the government. They wanted for the development purpose. In exchange for that, my lord, these lands were granted to me. These are the absolute properties of the government then. Because I gave around 4 acres of land to the government. Government gave me a land in somewhere else in exchange to that, and that is the grant order. So he made a rival claim, and subsequently, my lord, he has filed 2-3 injunction suits before the court. These 2 suits are pending. His brother filed a suit for adverse possession of the same property, that is pending. No injunction order, no interim order has been granted. This is the absolute property of the government then. This is the absolute property of the government.
When did you make your application for regularization of unauthorized occupation and cultivation?
1991.
When were you granted the land?
The opponent was granted in the year 1984.
18/8/1984.
My application is still pending consideration. I should have been heard before the revenue authority, which they have not done. When there was a threat, when they dig the borewell, when they came to the spot to dig the borewell, I came to know that there was a grant order in favor of my opponent. Immediately I went in appeal before the tribunal. Tribunal rejected my appeal on the ground it's barred by limitation. And spot inspection reports also indicate that I am in possession of the subject property. The revenue authority conducted a spot inspection. Even after grant, I am in possession of the subject property.
After 94, what you did?
I'm cultivating the land. The photographs are there, my lord.
My lords, I just draw my lord's attention to page number 281. A spot inspection report, which was spot inspection was done in the year 18/8/2023, 281, which shows that I am in the subject position of the subject property even today. It was nothing but a paper grant.
Stand of the government.
My lord, I have to secure instructions, my lord, in this matter. Because 84 was the grant in favor of respondent number 2, my lord, basically.
This land was.
There's a
granted
delay
to
of
me.
19 years. They had gone before the tribunal challenging the grant. Grant was in 84 in favor of respondent number 2.
94.
Now, what did the revenue record say after 1994?
It's my name is entered
When, from when?
subsequently after the grant.
No, from when did your name first appear in the revenue records?
Revenue records, my lord, it was entered, which is at document number.
The first RTC in your name, and when did the mutation take place? From when you are paying taxes?
I'm paying tax, my lord, since then. It was 2016 onwards, 7.
If you show the RTC of 1990s.
1996, my lord.
One single doesn't accept your reasons.
My lord, 1996, my lord.
Show the RTC something,
Yeah.
some revenue.
It's the document number 120, my lord, of the.
120.
Yes.
120 speaks 2021-22.
Not that. Para number 10, my lord, mutations so and so, 125/95/96, the column number 10. The mutation was entered, though the RTC is 2021 for 22, but mutation entry, my lord, it was MSR 125/95/96, immediately after the grant.
281 page may be looked into, spot inspection report, which you.
No, that is different. Revenue documents, RTC was standing in his name from 95/96.
Yes.
You are not disputing it.
I am not, because we are not aware is only the.
Yeah, it's okay.
check. That's all is my case.
Land given by the church to the government. Found the year 1990, this happens. This one. 95/96. The revenue document. And in the money, the second.
Where are the reasons for delay?
Yes. My lords, application for condonation of delay is narrated in page number 70, sir.
Page number?
Page 70.
Yep.
Sir, it starts from page number 71, sir. Second paragraph. And to substantiate my stand is that I am in actual physical possession of the subject property. There is a spot inspection report. That is one thing.
How did-
And grant order also says
How
that
do
physical
you-
possession has to be handed over.
3 injunction suits
I'm
are.
sorry,
filed.
When you came into possession, in what, by what means you are in possession?
Yes, I have got some Varga land. My lords, I am the owner of some Varga property. Attaching Varga land, there is a Kumki land. This is the subject matter of list.
Yes.
So for the better enjoyment of Varga land, I am taking the benefits of Kumki land,
But you
for
just
which I made an application for regularization of land.
granted.
Sir? No, he was not granted. He was allotted a land in exchange of the land which is,
Your application was never granted.
my application is still pending consideration, sir.
Then what, what right you can enforce?
Sir, all that I can say is that I am in physical possession. My application is still pending consideration. All that I was requesting before the tribunal is that since my application is pending consideration, since I am in actual physical possession of the subject property, I should have heard with the matter before the revenue authority, which they have not done so. In addition to that, my lords, at the time of issuing a grant order in favor of my opponent, there is a specific recital saying that the possession of the subject property has to be allotted to the grantee. All that I have stated my application for condonation of delay saying that though there was a grant order, it's a paper grant. Actual physical possession continued with my possession is my respectful submission. And in total, my lords, I will rest my argument saying that it is not the length of delay is not a criteria. It is a cause for delay to be examined, which the learned single judge has not done so is my respectful submission. I'm grateful.
Sorry, please.
Number 15, is Shwetanand.
I'm sorry,
Bill.
my lord, every day I'm coming for the same identical matters. Each day cases are being listed. It's connected and it is posted on 30th, many matters.
30th.
Yes.
Yes, my lord. So same
I
order.
take notice for Asma number 3. Your Lordship.
I'll take notice. I have already
Notice
informed
written
them.
on 30th January.
Available.
And I'll serve a copy on the council who appeared. I'm sorry, my lord.
Learned advocate Mr. So accepts notice on behalf of
Asma number 3, Union of India. my lords.
1-3.
Available.
Published.
Number 16, Mr. Madhukar Deshpande.
Delay.
Lord, there is some 13 days delay. Lord, there are two substantial questions that arise. One of territorial jurisdiction, the other one is scope of review. Lord, the appellant in railways, Southwest Southern Railways, had awarded a contract for doubling of certain tracks in Karnataka. And in the contract, my lord, there were a couple of clauses. Number one, the jurisdiction was specifically conferred on the Honorable High Court of.
Issue notice in both, nothing beyond.
I'm sorry.
Notice in delay as well in appeal.
This is for the first time it is coming up, my lord. I'll have to take out notice.
Therefore, notice.
Yes.
Notice.
My lord, may I serve the counsel who appeared in the writ proceedings?
When shall we keep? 19th.
Lord, the single judge has literally directed us to, cause there is arbitration clause, there is territorial jurisdiction conferred on the Honorable Kerala High Court. In spite of that, my lord, he has exercised his jurisdiction. In the impugned order, he notes that there is a particular clause by which jurisdiction is conferred on the Honorable Kerala High Court. But yet he interferes and kind of literally directs us to refund the forfeited money. I have followed the contract. So
When shall we give it?
Second week or third week of February, my lords.
Third week of February will do, 18th February.
8. I'm grateful.
Notice in both. The third learned editions of Mr. Kama. Applicant appellant notice.
Grateful.
17, Mr. Bhaskar Joyce.
Appearing for the appellant. This is an IA, kindly see page number, your lordship may kindly see page number 2 of the IA and 3 of, and 3, paragraph 1, 3 to 5. Yeah, 3 to 5. My lord, I was the petitioner in writ petition in the above writ appeal filed 24/541/23, seeking the relief of praying to grant of UGC AICT pay scale retrospectively. Additionally, 2 additional annual increment as per interim order dated 19/12/19, which is with earned leave encashment, which is due from the respondent. The order was challenged in writ petition number 24/541. It is submitted that under writ petition 24/541/23, the learned single judge disposed of 25/12/2000 by giving reason suppression of material fact. Respondent, without looking into the interim order dated 19/12/2024 in writ petition number 9582. While ordering writ petition number 24/541/23, the learned single judge has referred Supreme Court judgment Civil Appeal 2205/2007. But he could not pointed out regarding the maintainability of suppression of facts. Hence, the writ appeal has been filed now for stay of impugned order. Since the Supreme Court judgment has not been fully taken into consideration, therefore writ appeal is necessitated. After seeing the interim order, the learned press passed page number 62 to 65 of the writ petition. Annexure J, wherein the similarly situated person under writ petition in this division bench writ petition, writ appeal number 932 to 933, 1974. In this case of Sri Vinod and another versus State of Karnataka another, once an interim order relief is granted, one set of litigants, the same needs to be extended to the other similarly circumstances situated. Here, the technical staff which are being given, similarly situated person have been given at the age of superannuation 62 years. So there is a discrimination regarding the appellant's writ petition, appellant's request. So kindly see that paragraph 5 of the interim, paragraph 5 of the IA. I submit that I have worked for nearly 33 years without any remark, and respondent has paid salary considering my age of 62 years, but without paying UGC AICT pay scale with another retirement benefit due to respondent till date. Further, I submit that the other similarly placed technical staff has been paid and on account of this, I am discriminated.
You are a non-teaching staff.
Non-technical staff, but they're considered as a technical staff by sending the training. Training has been given and they have given salary also for the 2 years extended period. Therefore, I pray that this stay may be kindly granted and this petition may be taken upon.
So the only direction is to consider what is this order is not against you. The order of learned single judge cannot be said to be against you. He has directed the university to your private party.
But there is a discrimination.
What discrimination?
Discrimination is the other similarly situated people given.
Such claim of earned leave shall be considered in accordance with law by university. So what is to be appealed against?
In the earlier, in the earlier writ petition, there is a, there is.
9582.
Uh, So the discrimination is given because the same similarly situated people has been given. But whereas in this appellant side, they are not given the,
Where is that the others are given?
beg your pardon.
From where you are pointing out that the others are given?
Kindly see the grounds
No,
annexure
not grounds, not grounds. Any
No.
document, any substantiation.
substantiated, annexure. Just 1 minute. Kindly see page number 62 of the page 62. Page number 62, para 60, in page number 64, there is a one, there is 1, 2, 3, fourth paragraph. In 64, fourth paragraph, I will just read out, my lord. A matter merit deeper consideration and on the principle of parity as held by the division bench of this court, writ appeal number 932, 933, 1974. In the case of Sri Vinod and another versus state of Karnataka and another, once an interim relief is granted to one set of litigants, the same needs to be extended to other similarly circumstances persons, subject to all such exceptions which are not made out therein. This is the one. And in page number 66, translated copy.
This is interim order.
That is preamble is the 66 translation copy of Annexure K. Annexure K, I will just read out. In the paragraph 67, second paragraph, third paragraph. Sri K.S. Anand, lab assistant, chemistry department, and B.K. Srinivas. Here he is the appellant, B.K. Srinivas. Technical assistant, maths department have completed 62 years of age as on 31/5/2021. Hence, subject to the final order of the court, there are relieved from university service as on 31/5/2021, Monday afternoon. So he has been considered at the age of 62. So that 62 years he has completed and paid salary also for the 2 years. But the other increment and other things they have not given. So that is why there is a, in the writ petition, it is not considered the judgment.
This 9582 is pending. Petition number 9582 is pending.
9581 is disposed.
Dispose of, very final
Disposed.
order. You can't base some mandamus on the basis of interim order. You are seeking mandamus on the basis of some interim order.
Interim order.
Which is already disposed of finally.
Uh,
So how can you seek a mandamus on the basis of interim order?
Interim order just to get the stay for the writ petition. That's
Where is the final order of 9582?
9582, final order.
Oh.
95, annexure 62, page 62, final order.
That is interim order. Third learned advocate, so and so and so, sorry. Full stop, before the learned single judge, the prayer of the petitioner appellant was to direct the respondent university to grant UGC scale retrospectively. And a further direction was sought for to grant all consequences and benefits pursuant to extension of 2 years of service by virtue of interim order dated 19/12/19, passed in the writ petition number 9582 of 19. Full stop, by considering the representation. Full stop. Learn a single judge in the ultimate analysis passed direction stating that the claim of the petitioner, including
24,541.
leave encashment, which was not paid, shall be considered by the
because there was an earlier round of litigation and was not successful, it culminated in writ appeal. This prayer was basically
or learned with petition, appellant petition.
With your direct permission, annexure Q also gets supporting for this because annexure Q university, the respondent has given the endorsement stating that the sanction is also accorded to the payment. BK Srinivas and Pradeep Sridhar, both have been included. And also annexure Q, page number 98, there is also an issue that sanction of vacation leave beneficiary. In response to your letter, I also requested to kindly furnish the period of deputation. BK Srinivas has been included in that.
Third learned advocate, Mr. So-and-so, the appellant. The present appeal is directed against judgment and order dated 25th October 24 by learned single judge. The writ petition came to be disposed of paragraph by providing that the claim of the petitioner in respect of the earned leave encashment will be considered by the university in accordance with law within stipulated time. Paragraph. Before learned single judge, what was prayed by the petitioner, paragraph. Photos sprayed by learned single judge. Photos sprayed before the learned single judge. Was to grant to the petitioner. Was to direct the respondent university to grant UGC pay scale to the petitioner retrospectively. It was next sprayed to grant all the consequential benefits pursuant to extension or continuation of 2 years service by virtue of interim order dated 19/12/2019. Full stop. On more than one considerations, learned single judge did not find the prayers meritorious to be granted. Firstly, the basis of the prayer was interim order dated 19/12/19, which was passed in writ petition number 9582 of 2019. Full stop. The said petition came to be dismissed. By order dated the said petition came to be dismissed and the order was taken in appeal number 843 of 2023, which was also disposed of. Affording the dismissal of the petition with cost imposed on the petition to the extent of 10,000. Full stop. Learned single judge observed that in the facts of the case, the benefit claim by the petitioner was not available to non-teaching staff, to which category the petitioner belonged, having served as technical assistant. Full stop. It was noted that the university has received endorsement dated 8/10/1998, wherein it was observed that since the petitioner held non-teaching post, he was not entitled to the relief. We want to entitled to the benefit claim for by him. The said endorsement dated 8/10/1998 was never challenged and thus was accepted by the petitioner, in which the petitioner is finally treated as non-teaching staff. Full stop. The only question left, in other words, the petitioner who retired in 2021 was not considered entitled to continue beyond 58 years. And up to 60 years, which was the retirement date for the teaching staff and not the non-teaching staff. The only aspect paragraph left for learned single to be considered was the entitlement of the petitioner about payment of leave encashment as per the admitted pay scale and service conditions of the petitioner. In this regard, learned single judge directed the university to take appropriate decision in accordance with law within stipulated time. Full stop. On closer examination of the examination of the facts and considering the findings of the learned single judge, the petition does not, the challenge in the petition, the judgment and order of learned single judge does not book any error. The challenge is meritless. The appeal is dismissed.
Seal number 18.
My lord, I appear for the respondent number 1 in seal number 18, my lord.
Appear for the petitioner, my lord. This is a PIL challenging the agricultural marketing policy of 2013, my lord, on the ground that it brings in private players into the agricultural marketing policy and the working itself.
What is 18.1 which were, therefore we are looking at. The rate maintainable. How is the rate maintainable? You have found? Same. Same.
It is similar, both the petitions are
You're
similar,
also,
my lord.
you're also challenging the policy of 2013.
Yes, ma'am.
2013.
Yes, my lord.
On what ground?
On the ground that the policy itself was brought in to include,
On the grounds of policy considered.
it is a policy consideration, my lord.
Is good.
But taking into account the case of Brijmohan Lal, my lord, which laid down tests in para number 100 on what basis a policy can be challenged in the court, and the judicial review extends to also quashing policies if they are unconstitutional, my lord. I'm happy to argue the matter, my lord, provided there's a date fixed, because counsel here is seeking some time. So I'm happy to argue the matter, my lord, and place.
We are also happy to listen your argument. This is which year?
2021.
21, your
My lord,
Yes. You are also happy to argue or not?
No relief is sought against me, your lord.
Pardon?
No relief against us, my lord.
Then why do you sit down?
my lord, learned advocate general will be appearing.
Policy
My lord.
matter challenge there, lords there.
That is exactly the point.
Policy matter.
That's the only point.
Yes.
Even the ground to challenge the policy is a policy concern.
No, my lord, it's a law laid down by the Honorable Supreme Court, my lord.
Which judgment? Like?
The Brijmohan Lal judgment, my lord. 2017-10 SCC 1, my lord.
This has been implemented since 2013. So
My
today
lord,
we are in 11th year of
the challenge is on the very short point that private players have been brought in, because of which the data pertaining to the prices of the agricultural commodities has been compromised, my lord. I'm challenging it only on that short point, my lord. I'm not challenging the entire policy itself.
Correct, but what is that? What is the statutory base or constitutional point in challenging? Any ground?
The ground is that because of that, private players, till the policy was put into place, my lord, the APMC markets were the sites at which the agricultural commodities were sold, my lord. Now, because this policy has come in, it has brought in several private players, because of which agricultural commodities are being put up on the stock exchange. Now, our simple point is that our data, the data pertaining to prices, pertaining to the commodities itself, are going on to the agricultural marketing commodities exchange, my lord. Now, that is also going to the private players itself. So the prices itself, the data pertaining to prices is being compromised, my lord. That is our short point, my lord.
Yes, madam.
My lord, he wants to argue, my lord,
Who?
learned advocate general. I'm not asking for a long date, my lord, short.
My lord, one submission, my lord, there is no relief sought against the Union of India, my lord, in this petition. Only short prayer is regarding Union of India is the data protection, my lord. Already there is. This affects the traders basically, not the farmers.
It affects the farmers directly, my lord, because of which the farmers' commodities prices
Farmers
are
are
up
benefited.
out to the open, my lord.
Tremendously benefited. Farmers are tremendously benefited.
And with the technology, probably they will have buyers at their farmland
More
itself,
paying.
rather than bringing it to.
In fact, they will know the pricing of the product.
In fact, several issues.
Pricing
overlap-
itself will be there.
My lords,
It
Several
itself
issues
is not maintainable there, my lords.
Several issues overlap with the,
You understand?
no, not with the traders, my lord. We are here representing the farmers, my lord. Several issues overlap with the farm laws, which itself were repealed, my lord. Several issues overlap. In fact, I can produce the specific provisions of the farm laws, which are also pertinent to our case, my lord.
Well, you are strong
Again,
enough to
maybe
have the presence of learned advocate.
Any date may be fixed, my lord.
When the advocate general is coming?
My lord, 2 weeks, my lord. Very well, my lord may
Too
fix the
long
date.
week.
too long again.
Very well, my lord may fix the date, my lord.
6th of February.
5th. Sixth, obliged.
Yes, my lord.
Obliged.
Great.
Get you, that's.
2 meters, yes.
Reading. Lord. Question number 19.
Lord, I'm for the petitioners, Lord.
Raj.
The construction of commercial building on a lake bed, my lord. He being a ex-MLA, my lord, taken law into his own hands and started putting up. Sale deed is fabricated, my lord, for the purpose of obtaining a conversion order. In sale deed, the boundaries has been shown. May I take your lordship kind attention? This is a petition filed by the petitioners. They are the resident of the particular village, Muruganhalli, my lord. My lord, they agreed by the construction activities being taken by the 12th respondent, my lord. They filed this public interest litigation. My lord, the sale deed which has been produced as Annexure A, my lord, which depicts the boundaries of entire property, my lord. The boundaries of the entire property, my lord, east, the west and south says tank bed, my lord. For the purpose of conversion, my lord, the document became to be fabricated, and subsequently, my lord, 11E sketch is obtained and followed by other activities, my lord. Then they put up a construction and put up a plant for the purpose of production of RMC, my lord. Ready-made concrete machine they have put up, and they have been doing the commercial activities on the lake bed. And there is a buffer zone, my lord. Even then also they did not leave the buffer zone. This is the sum and substance of the case, my lord. And the 12th respondent being a MLA, my lord, he had taken all the services of the government, my lord, by obtaining, concocted the document for the purpose of conversion, my lord. The sale deed speaks that the sale deed, my lord, the lordship would translated copy, my lord. Ink page number 44, my lord. The sale deed boundaries, which shows in ink page number 43, east, west, north and south, and west by tank area and south by tank area, my lord.
Have you produced the 92 partition deed?
Sale deed I have produced what the 12th respondent purchased.
Probably we'll get some more insights in 92 partition deed. That has been referred to the sale deed.
What under the transfer
To determine the schedule of the property. And government will have to probably answer whether it's a tank bed or not.
No replies also.
I just make some preliminary submissions, Marz. Of course, one is, it appears as if it seems to be a roving inquiry. The petition averment seemed to suggest that I'm in the buffer area. Now my learned friend made a submission that I'm in the tank bed. Then the next submission was the conversion order was obtained by so-called collusion. It seems to be a roving inquiry. This land was purchased about 13 years ago, 25th January 2012. Conversion order is of 19/1/2016. So we are 9 years down the line from the, of course, this petition was filed, I think, in 2022, but even then, Manoj, it was 6 years later. And they filed a representation before the deputy commissioner. Let the deputy commissioner consider it, Manoj. That's what appears to be. And in fact, I have a even more preliminary submission to make. Now, under the PIL rules of this honorable court.
For number 12.
I'm sorry, Manoj. I'm for respondent number 12. Now, as per the PIL rules of this honorable court, the petitioners are required to file a pro forma affidavit disclosing various details. The affidavit file, I'll take my laws through. The affidavit file says petition number 2 and 3 are residents. No whisper about petition number 1. In fact, petitions have been dismissed on the ground that it is not in compliance with these rules. And admittedly, when this petition was filed, those rules were in force. Kindly see, my lords, page number 19 of the petition. This is a part of the pro forma affidavit. My lords has paragraph 2. The petitioners are permanent residents of the above mentioned address. And petitioner number 2 and 3 are residents of so-and-so village situated in so-and-so taluk, Chikballapur district. They themselves and the villagers are deeply and seriously affected parties since the commercial building is constructed and the buffer zone of the so-and-so village tank bed and so-and-so. Now, kindly see, my lords, what the rules require. First of all, my lords, petition number 2 and 3 are supposed to be residents of the village.
petition number 1, admittedly as per the cause title is a resident of Chintamani, not the village.
Same taluk.
Then kindly see what the rules require, my lords. Rule number 11, PIL rules.
Bank conservation.
You will have to take action.
The number of custodian of the day is the 50 commissioner and
I request my lords to kindly see Rule 11. A writ petition in the nature of public interest litigation filed in the High Court of Karnataka shall, as far as possible, disclose petitioner's name, complete postal and email address, phone number, proof regarding personal identification, occupation and annual income, PAN and so-and-so card number, petitioner's social standing, professional status, and his antecedents. Nothing is disclosed, my lords.
Email address is shown.
My lord, I'll file, my lord.
you also comply with this rule, at least.
No, my lord, email address is shown, my lord. That's what my learned friend want is. Email and everything is shown in the cost title. Probably my learned friend has taken the other side of
Form
the.
shall be filed by the government and the parties concerned within 2 weeks. Petition shall be listed on 3rd page.
Obliged.
So 24th February.
My lord, 24th, I'm not there. 23rd March is only. 3rd March.
Number 20.
20, my lord,
State
state appeal, my lord.
Appear for the complainant, my lords.
I'm seeking for a short accommodation in the matter, my lord. Learned EAG is appearing in the matter. A short accommodation in the matter.
My lords, the order of the learned single judge, my lords, is dated 11th October 2023. I'm not opposing the adjournment, my lords. I request for a short date to be fixed, my lords. AG had informed.
20th February.
Grateful.
Grateful, my lords.
Yes. Next.
So number 21.
I appear for the appellant, my lord. The matter may kindly be passed over, my lord. I will appear physically.
But we can condone the delay of 12
Yes,
days.
my lord. 12 days delay may be condoned, my lord.
Delay of
They
12
have
days.
filed an execution
Very nice.
petition.
The effects of the case. Delay of 12 days in filing the appeal is condoned. A sufficient cause is made out, application is allowed. So appeal may be listed on some other day.
A short accommodation may kindly be granted, my lord.
10th
They have
February.
filed execution petition, my lord. That is
10th
fine.
February.
Much about much.
So number 22. AMC Basuraj.
Password.
22. AMC
22, you are at 22. 22 pass out.
22 respondent is here. He's sitting there, 22. Fundament is.
No.
22.
We condone the delay in 21.
Yeah, we condoned it.
21 also we can condone that. Where is, nobody is there.
Yeah, 21 we condoned, sir.
Oh.
We condoned that. People who are condemnation of the 42 days. Look for respondent number 1 to 3 sitting there.
Number 22 with HRN.
HRN.
Call out 21.
21 is over, sir.
22 call out.
22.
Yes, my lord. Delay could be good.
Delay condoned. Same order. 42 days. Upalina heard in the beginning, both orders heard learned advocates for the respective parties. Full stop. They have considered the averments in the supporting affidavit, which explains the passage of time leading to occurrence of delay. Both you same.
Number 23. Beg to appear for the appellant.
I'm for first respondent.
24 day is there in file.
Twenty-four days delay, so it can be counted down. So same order, 24 days. So now what is, today it is be argued, appeal?
As my lord, sir.
You can argue, we have no difficulty.
Please. 10 to. Based on a complaint, my lords.
So they were not able to specify the land.
They were not able to specify the land. That was the allegations. After that, there was a committee which also held an inquiry. They could not be able to give a alternate land during the process. In the meanwhile, this was also based on a complaint by the person who was the second person who was not being allotted the dealership, because there was lots. There's equal competitors, so there was lots which were picked, and the first respondent was selected. The second person lodged a complaint based on which we issued a show cause notice. Show cause notice was challenged before the learned single judge. Now, that is quashed and the directions are issued to me. In the meanwhile, my lords, a writ petition is filed by the other person and there is an interim order there also.
Sorry, there is no interim order.
Stuck in two places. One is a final order, one is an interim order, asking me not to. The land evaluation committee held its inspection and found out that what was given earlier, that had been withdrawn. The lease was terminated and withdrawn by them. And as on the date of inspection, that was not available. That was the suppression of fact which was done. That is the.
So the complaint was time barred.
Complaint is treated as time barred, is what the.
In light of which provision?
Under the brochures, my lord, brochure is ink page number 48, my lords will find the brochure.
Now the deficiency of alternative land is remains or it is met with?
The land was available. The subsequent land was available. The previous land which was, the process is like this, my lord, as per the condition that while an alternate land is given, the earlier land should be there, available.
There is
That was not there while the inspection was held. That land they had already surrendered and suddenly a new land was given by them.
At the same place?
No, different place altogether. I mean, it's the same location is somewhat similar.
Within your.
Yes, please,
same.
please.
So what is your ground of?
Pardon me.
What is your ground?
My lord, my only, this one is, my lord, final order is there. The person who has come second also has filed a writ petition with the complainant. And there is an interim order which says the result of that will depend. I mean, the allocation in favor of this first respondent will depend on the result in that writ petition, which is still pending.
This first respondent was granted the letter of intent also.
Letter of intent. The first respondent was granted the letter of intent based on the allotment.
Lying thereby everything was fulfilled, including the land.
Yes.
Letter of intent is issued. In that time, 30 days time is given for somebody to raise a complaint. The complaint files a complaint after the launch of the code. The only question that remains with consultation is there any material.
See, first, they indicate a particular piece of land
Please,
as available.
please,
Okay.
please.
Then in draw of lots,
Successful
the
bidder.
original petitioner is successful.
Please.
Thereafter, he says this land is not applicable, some other piece of land is not applicable.
Please, alternate land.
Alternate land is there.
Please.
Here, two questions arises. Number one, was there any suppression of material fact which vitiated the allotment process, or is there any problem with regard to alternate land given by the original petitioner?
No. So far as the first condition is concerned, according to the appreciation, my lord, there was suppression, but the second alternate land was given, it is suitable.
What is that suppression? Does it really warrant cancellation?
We only issued a show cause notice, my lord.
That's all.
That's a stage.
You
of
have
show
not
cause
yet
notice.
come to the
We
conclusion.
have not come to the conclusion.
You in fact accept the alternate land and you have issued the letter of intent.
Yes. Subsequently, I have also,
Okay.
other process also they completed.
And they complete the other process also,
Please.
and the present location is suitable and fit for establishment of a petrol bunk,
Please.
and the original petitioner has the necessary leasehold rights over the said property.
Said alternate land, yes.
Yes, alternate land has the necessary leasehold rights for the said property.
Please.
Then 30 days is given by you for somebody to prefer a complaint.
Prefer a complaint.
Correct.
Beyond that, the complaint is.
Yeah,
lodged.
now the complaint is received beyond 30 days.
Please.
And your lordship, they are already considered the complaint also. Kindly see, your lordship, they are also given an endorsement.
Yeah.
Nothing remains there.
Kindly take, they have given an endorsement to that person. Right side, worship, the complaint has not been received within a 30 days of the selection of applicant. They have already rejected their request. They are not brought to this important, worship, the document before the learned single judge also.
Recipient has endorsed.
Complaint not been received. Was
Not been. Sir.
And one more interesting, worship, on the basis of that person complaint, they have initiated the proceedings. Now, your lordship, ultimately, your lordship, the proceedings ends with your lordship in our favor. They consider their request also. The person who has given an application for a good person, their application.
They initiated proceedings
Yes, your lordship. They already consider their grievance also independently. Nothing, nothing, your lordship. There is no single error in the order of the learned single judge.
No.
There is a provision under the brochure to give alternate land. Accordingly, I have given alternate land.
My lord, I am only on two counts, my lord. One is that it was a show cause notice. They could have responded and I would have adjudicated the matter. That apart, but there is another writ petition which is filed by the other person. I am.
That's okay. With regard to show cause notice, if you don't have any serious grievance,
Please.
as of now,
Please.
it's as good as replied.
That is the other petition. What is the consequence if my lords are to say that? I will be at least lesser of a burden because I should not be committing contempt of court in that order.
So, what is the order passed in the other petition?
Other petition, I have produced the copy.
Subject
Along
of
with
some
an
application.
Subject outcome this.
Correct.
Consequence of the writ.
They have filed a mandamus, writ of mandamus. Writ of mandamus, they have filed a writ of mandamus. In that writ of mandamus, the learned
Where is the order?
That is
Not there.
annexure document 234, my lord, page number 234.
234.
There is no
And
interim
lots
order.
will find it at
There is no
235.
interim order.
235.
Just subject outcome of the result. That is not a, that is not precluded to your lordship, the compel the order of the learned single judge. Subject outcome of the result. Ultimately, your lordship, this writ petition goes, that writ petition will goes before the learned single judge.
That dismissal,
After considering this order,
that writ petition goes, my lords, then
that is only their difficulty.
no harder. That is only difficulty which I am facing now. Video.
235, no.
235, my lords. The last line there, the allotment is in favor of respondent number 3 shall remain subject to the result of the petition.
That is only simple. Any of the subsequent order, the writ petition also become infectious.
As a company, I am responsible, I am answerable to that court also, so. I'm stuck with that, my lord. This is the only thing which, as a company, I need to,
The other petition is for what?
that is for mandamus.
Mandamus considering the representation only, that is only,
Filed by whom?
that is also time bound.
Complainant.
They have already given
Complainant.
endorsement also.
Complainant.
Complaint. That is the person second in number.
But we are dismissing. Please.
My request is, my lord, kindly observation on that particular consequences of that repetition may also.
That you can take advantage of the dismissal of this, either of.
I'll be grateful. Obliged.
When that petition is coming up?
I think they have filed a memo
Oh,
putting up
very
that, because GM courts are a bit rushful courts. So grateful.
So number 24. Mr. Raghavendra Ji Gayatri.
Okay, for the pleading application. I may not have serious object, no copies served on. Let this application be taken up along with the main melody at the time.
Lords, for the reason I filed in pleading application is, Lords, PIL was initially filed by Lords members who are elected in the municipal council. Relief is sought against government, not against municipal council, because road construction that was sanctioned under the scheme 3, that was not further proceeded to. That is the reason PIL has come to picture, my lords. In now, my lords, the members are about to retire, tenure is about to go. That is the reason I filed in pleading application where publics of the residents of the said area are contesting. My lords, if I can say the facts, my lords. May I?
They have started the work or not work for?
Lords, what happened is,
Gandhi and Gandhi Cross Road.
My lord, on merits, my lord.
Lords,
On
it is from
merits, my
Kallapu
lord,
Junction
I
to
need
Burdu.
some time, my lord. It may not survive now. Let me get the latest instructions.
It's a town municipal council who has. to
Entire
reply.
allegation is a portion of the road is not laid. It was in 2021 writ petition. Now perhaps they must have.
Portion of the road
Not,
is
not
not
still
laid.
constructed.
Not laid. That's
This is the only.
it is still, they might have done it now, completed.
Not, my
also.
lords, that is my grievance. They have not constructed till from past 4 years. That's by sanction.
Let me take the latest instructions. This application may be considered along with the main melody. I may not have the objection melody for them being implemented. I do not know. They have not served a copy of the application also.
No, that is all. This is only one PIL. To find out if the road is completed.
I will.
Lord's mercy.
My lord,
Can I
the
seek a-
petitioner being a member of the
I
my
can-
lord, town municipal council doesn't see to it, my lord, that the road is completed.
You are town municipal council.
I'm member and relief is not served against a town municipal council for the reason it is the government who has to send the funds. And town municipal council is only in order to send the plan is concerned. And we have sent the plan. Government has directed vide annexure D only sanctioned 15 crore among 100 crores. Rest of the money is not sanctioned. I am being a member, I cannot ask relief against town municipal council, but I can ask relief against government. So government has not sanctioned the money.
The council.
If I was a legislative member, my lords, I cannot have locus. But under Article 243, I'm an independent body. So when I'm asking relief against government, government has to say why the funds have not been released. It is on that ground, construction has not taken place yet.
March.
My lord,
3rd March.
my lords, my apologies, my lords, but can I ask in the February because the petitioner now contesting will, the tenure will be over by end of Feb, my lords.
Who's standing?
My lords, petitioners.
He's
Petitioner.
a member of respondent number 5.
That's why I filed impleading application. Otherwise that may be allowed.
Lord,
There is no merit will dismiss.
Lords, I will have maintainability for the reason I'm not claiming relief against municipal council. Lord. And even the publics are contesting it now by way of impleading application.
See, your term getting over
Yes, my lords.
will not have any bearing if you are asking a relief against the state government.
Lords, but even the public is contesting it now.
My instructions, my lord.
I have filed impleading application to that effect also.
Roads, my lord, they go on repairing, my lord, even if it is, we are in contract work was in 2018.
Counters are filed or not?
No, my lords.
no, my lord, because it was the town
I
municipal
will find
council.
out.
Find out. Yes.
Find out.
10 or to 19th February.
Deeply obliged, deeply obliged.
Somewhere after 3rd March or 4th.
3rd March.
Number 25, Mr. G.S. Venkata Subbrao.
Petition this matter.
My lord, if it could be taken up at 2:30, my lord, the English translation has been misplaced in the office. I will get it.
Must may have it next week, my lord.
Why?
In the meantime, I will file my objection also in the matter. I am for the 6th and 7th respondent.
This is about liquor shop.
Yes, my lord.
My lord.
Set up and located within the,
Yes, within 100, whether it is within 100 meters or not.
And
And the Tahsildar had been directed to inspect and submit a report directly to.
that report is copy also we are not received, my lord. And even there is a provision, my lord, even if it is less than 100 meters, there is a provision under the Excise Act.
let the report come at 2:30.
Yes,
2:30.
2:30.
My lord, since he's not well, if my lord could have it on Monday, my lord.
Who is not? You are not well.
yes, my lord, I am undergoing for
All right.
operation.
That-
Call it otherwise after 2 weeks, my lord.
That you did not say anyway. Then wait, when do you want?
After 2 weeks.
After 2 weeks?
Yes, I am going for under operation.
All right. 10th March.
Much of it. Lord, interim order may kindly be extended.
Interim orders will stand extended. 10 to 10th March as requested by the council for that conduct.
Flash.
Number 26.
I
CH-1.
agree of the petitioner, Lord. So PIL relating to allotment of land
Your Lordship,
for Muslim burial ground.
if a short accommodation can be kindly granted, Your Lordship, for the
Every matter to be adjourned. You are
for the impleading applicant, Your Lordship.
impleading it. Let us see what it is. Burial ground.
My lord, yes, my lord. But the main contention, my lord, is this, that this land which has been granted in Begur village, my lord, is completely unmindful of what that land is. My lord, there is an old temple Kalyani there. There were a number of trees there. And
You find out this is hanging since now. What is going on?
My lord, I produced the photographs. My lord, I filed the statement of objections. My lord may see the, my lord, the position of the land, my lord, and even the tank which they say is the Kalyani. My lord, no, my lord, and there is no burial, my lord, that has taken place. The land has been handed over to BBMP. The order of the Deputy Commissioner admittedly is appealable under Section 49C of the Karnataka Land Revenue Act. I have met each and every contention, my lord.
This land is also, my lord, Gundutopu, which is meant to be reserved for trees. The reports, my lord, submitted by the authorities are available, my lord, from page number 167 onwards in the writ petition. There are more than one report. At 168, serial number 10, the report, my lord, of the Tahsildar.
168.
168. Type of land, Gomala, and is shown as Gundu Topu. Topu, my lord, is an area where there is dense tree vegetation. If there are a number of trees planted, my lord, in Kannada, they call it Topu, my lord. Mavin Topu means mango ground. Next, my lord, at page 170, the inspection report shows item 20.
What is it?
Gundu Topu. Topu, my lord, is a place where large number of trees are grown. If we plant casuarina trees or mango trees or other holy trees, my lord, that area is called Topu. At page 170, this is again the report only, my lord, of the Tahsildar, serial number 25. Details to be submitted after spot inspection. Type of land, distance, etc. There are 11 old trees in this land, one Kalyani. It has not come to light. Form 50 and 50, the applications are not pending. So this is a position around the date of inspection. Now, one more inspection report is at page 197. This land, my lord, has no access from the main road also or from any road. 197. We have seen on this day rough sketch prepared by revenue inspector in survey number 369 measuring 1 acre 26 quintas. In this, the trees, katte, ponds, etc. are found. Well, Kalyani is existing. Temple, plants and trees to be reserved in blocks. Toddy trees, sandalwood and others. Extent and public utilities retained such as cow shelters, nala, canals, ditches, ponds, graveyards, roads, temples, wells, pathways, mantap, cart road, details if found in the sketch. Kalyani is existing. When the AC reports to the DC also, he makes his point very clear, my lord, at page 216. There are two reports, my lord. Kindly first turn to page 212. Second para. Vide reference 2. The Deputy Tahsildar has submitted a report as per which the total extent of land in Akarband, survey number 369, Begur, is 1 acre 26 quintas. Entire extent is C Kharab. As per Karada copy, the said land is a Gundu Topu. As per RTC, the entire extent of 1 acre 26 quintas is Gundu Topu government land. Said land falls under BBHP jurisdiction, has 11 old trees, one Kalyani, according to map prepared to the surveyor. Above land is vacant. For the purpose of granting land to Muslim community for Kabristan, Darkhas memorandum form number 2 villages mahzars have been submitted. Then, my lord, at 216, the same thing is repeated, my lord, at 217. In the middle of 217, my lord, if a land is Gundu Topum, lord, that has to be de-reserved first before you can use it for any other purpose, like forest land. Middle of page 217. The said land falls under BBMP jurisdiction, has 11 old trees and 1 Kalyani or well. Since the proposed land is Gundu Topu land, it has to be de-reserved from public rights as per section 68(1) of the Land Revenue Act. That also is not done. On the basis of this, my lord, the DC straight away, my lord, without consideration of anything, grants the land. The grant order is at page 225, my lord. It is completely silent about what consideration have been made to this. At page 220.
My lord, this order is appealable under section 49C.
Who are you?
We are for the impleading applicant, Your Lordship.
No, they are the ones who gave a request to government to allot land to them for burial ground. I have produced material to show that in the vicinity of 5 kilometers, there are at least 4 Muslim burial grounds. I have given details, my lord. Totally, there are 11 burial grounds. I have filed those documents also, all the survey numbers, showing that this is Muslim burial ground.
My lord, I have met each and every contention that has been raised by the petitioners, my lord. And I have
But the
produced
records of the
photographs
government,
also.
if your lordship should peruse the record, my lord, before this order annexure Q is passed, it will become very apparent that none of these things have been considered, no application of mine, nothing whatsoever. Because all the reports consistently show that there is a holy temple, the Kalyani there. Trees are there. It is good.
They have earmarked the area for burial ground.
Yes, they have now, my lord, earmarked it as burial ground.
By passing some order.
Yes, this is the impugned order, my lord, is this. Annexure Q. There must be application of mind. My lord, before granting any land, there is a procedure also, my lord, that is envisaged in the land grant rules. Rule 3, my lord.
Any interim order is there?
No, my lord, your lordships have orally observed, they made a submission that nothing is happening. So till now, no burial has taken place. So that, my lord, may have to be preserved till your lordships would be pleased to hear it.
Implead him.
No, he is a complainant, my lord. My submission is this. He says he made a request to say grant. Land is not granted to him. It is only reserved for burial ground. So he is not a necessary party. It is essentially an action of the government. The deputy commissioner acting under the land grant rules, is he justified in doing this is a question that will arise. My lord, I may apply for any land anywhere. That doesn't mean I become a necessary party in litigation relating to the actual exercise of power by government. Government has to defend its action.
My lord, please see the photographs, my lord. What they call as a tank, as a well. My lord, it is a tank which is used for drinking purposes, my lord, by the cattle that grazes there. My lord, may I take my statement of objections? My lord, even otherwise, my lord, under section 49, my lord, see, it is appealable to the tribunal, the order of the deputy commissioner. They can bring all these facts to the notice of the tribunal.
This Kalyani is a tree or well.
It's a whole, it's a, my lord, Kalyani, my lord. I'm just giving, my lord, the definition of what is Kalyani, my lord. In the famous Kannada dictionary, I'm just giving for pictorial purposes, my lord, how temple Kalyanis, my lord, are usually built. My lord. Of course, the one in the definition, my lord. The second definition is Kalyani. Page 387 on the Aldner. They could have given some other land. The whole country, my lord, is agog now with what is happening. The second definition, about 7 or 8 lines from there, it says, Kalyani, one of the meanings is a square pond with steps on all sides.
Sir, Kalyani is essentially a water tank associated
Attached to
with
a
the temple.
Exactly. That's where it is.
Where the Abhishek, for Abhisheka, the water is fetched from the Kalyani. That's it. That's how
My lord was-
traditionally understood.
Yes.
That's it.
No, on the last occasion, my Honorable Chief Justice, my lord, wanted to know what is Kalyani, my lord. That's why I got this. Kalyani is typically, my lord, there will be a temple. Either it could be a Vishnu temple, Shiva temple, or Ganesha, any temple. Because for the ablutions in the temple, they need water. So they use the Kalyani pond water for bathing the deities by Abhisheka. And also, my lord, it is used for ceremonial occasions when the gods are placed on a kind of a float. It's called Tepotsava. And the idols, my lord, are taken around in the temple. Even Tirupati, my lord, there is a function like that which takes place in Balaji temple.
My lord, there
Now,
is
the
no-
argument at the other side is that this temple, this Kalyani has no water. There is some overgrowth and things like that. Naturally, my lord, over a period of
But
time.
none of the photographs show the existence of a temple, sir.
Yes.
No temple. I mean, we are not saying there's a temple there. As of today, there's no temple, but it was a pond, it was a Kalyani that was associated with it. That's the reports, my lord, consistent report.
But why they are earmarking this particular community?
There was an ancient Nagalingeshwara temple there.
Yeah.
It's not within this 1 acre and not, it is close to that. So, my lord, many times, these, if the area for the temple is not sufficient, some benefactor would come and build a Kalyani in another place. And that is the water which should be used. But all that I'm saying, my lord, is this in this PIL, my lord, if your lordships could please, my lord, see, with all this material being available, what has the deputy commissioner considered? If he has not considered any of these things, the records will bear out what they've seen, what they've not seen.
So your contention is mainly it's a Gundu Topo with a Kalyani over there.
Yeah.
And without following the due process, it has been
Reserved
that's
for
it.
this.
That's
Three submissions brought. One is factual issue not seen. Second is the fact that it is Gundu Topu is in the record, revenue record. They cannot de-reserve it without following procedure. Third is before any grant is made, they must make a list of all available lands. Not Rule 3 of the land grant rules requires a procedure. They have to make a list.
Yeah, that is without following the due process.
And no public notice and no hearing any affected person and no application of mine to the order itself. The order itself is absolutely bald. Nothing is adverted to him.
This public interest petition. Relates to earmarking of land in survey number 369 of Begur village, Begur Hobli, Bengaluru, South Taluk. Head measuring 1 acre and 26 guntha for the purpose of a graveyard for a particular community. Order in this regard dated 11/9/23 came to be passed by the Deputy Commissioner, Bengaluru Urban District. So specifying the land making it available for graveyard to particular community on the condition imposed in the order. It is this decision paragraph which is objected to by the public interest petitioner. Learned Senior Advocate Mr. Nagananda would submit that the land was not liable to be spared for public, for graveyard, inasmuch as situated on the land is a Kalyani. It was highlighted that Kalyani is a well which has religious significance. It is a pond attached to the religious place. Full stop. From the recorded while the reply is filed by the government producing certain photographs, and it was sought to be, and it is sought to be suggested that there is no indication that the Kalyani is in use, comma, it could be noticed from the record of the petition that the endorsement public order dated 11/9/23 of the Deputy Commissioner, whereby the land was given to the community for the purpose of graveyard, comma, preceded. Where is that? Where is the report?
Report, my lord, is that 197. There are three reports which your lordship perused. 170, page 170.
Yeah, we just we saw.
And 197.
The reports as many as 3 in numbers, comma, the reports suggest that it is a Gundu Thopu land.
Gundu Thopu.
Gundu Thopu
Gundu
land.
Thopu. That your lordships will get at page 168.
Yes. And we read page 168. Secondly, it is stated that the land has 11 old trees and there is one Kalyani integrated well. This is reflected in the map prepared by the surveyor. Even the impugned order notes this aspect of existence of 11 old trees and one Kalyani on the land. It was additionally submitted that other sites, as many as 4 in numbers, are available in the town. It is town, what is that?
In the vicinity, my lord. I have filed the details, not in the memo.
In the vicinity. To be used as graveyard by the very community. Full stop. Given the aforesaid facts reflected on the record, including in the surveyor's report, comma, the petition deserves to be heard finally it is to be listed for final hearing it shall be listed final hearing on 8th of April. The parties are directed to maintain status quo with regard to the subject matter land.
Lord, I had filed an application for impleadment.
Statement, your original complainant,
On my representation, only this land is reserved for.
we.
I've not even made a.
No, Lord, it's not granted to him.
One.
He gave a representation to say, please reserve this. So government reserved it. I can understand
the
if grant is to
beneficiary?
him.
Will make you the party.
My lord, they are necessary parties,
They
my
may
lord,
be-
because yes.
Your application is allowed.
Yes, and
Please.
my lord, this status quo order was never there right from the beginning. My lords have adjourned it at his instance several times, but there was no status
Not
quo
at my
order.
instance.
May I please complete? There was no status quo order. The only contention is there is a well or a pond from which the water is taken to, my lord, perform pujas in a temple nearby. I have produced the photographs, my lord. It is a place, a small little pond. It is so dirty, nobody can even, my lord, touch that water. It is, and number two, my lord,
Will get inspected if required again. At
the
the time-
report also,
At the time of taking the petition to logical end, we'll get it inspected.
Yes, my lord. My lord, last 2 years, what has happened because of all these proceedings, nobody is allowed to go there. So naturally, my lord, if in 2 years open space, overgrowth will be there. In city only, my lord, if one site is left vacant for 6 months after rain, it will
Who
be
is
full of
that?
weeds. So their photo shows there is weeds there.
how is that relevant to this case? I have even offered, my lord, at my cost, I will enclose the pond so that nobody will touch that. You can use.
What is his right?
Sir,
Who are you?
He's a Muslim body. Why should he enclose my pond or public pond?
my lord, if I
My
am
lord,
not even allowed to make my submission, my lord, with great respect, my learned friend said he will take time. When I go and sit in the other court, my lord, he starts the case.
Sorry, that was
No,
not-
no, no.
I can show you my message. I told my learned friend, I'm going to be here. If the honorable court adjourns it, I will not oppose it, but if the honorable court is hearing it, I will make
No,
it
my
submission.
lord. Even in the corridor, when I was going down, I have been sitting here from 10:30. My learned friend said, I told him I am called in the other court.
Please, we are-
All that is apart, my lord. All that I am requesting is, on my representation, your lordship said IA will be allowed. And nobody is not the case. There should be a beneficiary for whose benefit this land is reserved. 108, my lord, that section itself says,
We implead you in as a party respondent.
true, my lord, but the status
You
quo
can
order,
file reply also if you want.
Lord, I have already, Lord, put on record the statement of objections. And assuming on the last occasion, your lordship said, we will hear you on the impleading application. Now, my lord, the problem is this. There is no report that there is any burial ground. Adjacent to this burial ground, there are people whose, my lord, houses are located. They are the ones who are creating this problem. Who are the petitioners? What kind of public service they have done till today? Nothing is mentioned, except saying I am a resident of that village. What should happen to those who are dead? Where they should be buried?
You're saying there are other sites.
There is no such other site in the village or vicinity.
Before the next date, the petitioner shall file an additional affidavit in support of the petition.
Please.
Setting
Your
up
date.
setting out the details of the other grave
I've
available.
already filed, I'll file an affidavit. I
With the
filed
same
the
village.
documents also I filed.
My lord, I have met that contention also, my lord, with regard to the adjacent burial grounds that they have mentioned. There also, my lord, some of the burial grounds are full.
My lord, may I make one humble
That
request?
we do not know. How do we know?
My
My
lord,
lord, we
all
have,
that we will get it, my lord. One humble request. April will be too late, my lord.
Pardon?
Can it be advanced to end of February? Third week or 19th, 18th, 20th, any date, my lord.
4th March.
Right.
4th March.
Yes.
Give for impleading. Yes, what is it?
Yes, sir. I'm for the accused. In view of my undertaking last time,
This is the
I've
matter
handed
which-
over the vehicle to the party.
This is the matter which they undertook to give back the vehicle and withdraw all the,
Yes, I have.
they have just given the vehicle back. But I'm told that RC is transferred to auction purchases name. That has not.
Produce the photographs also. And in view of the miscommunication, your lordship, these
In furtherance of the statement made by learned counsel for the respondent that the bank had decided to withdraw all the actions which were found to be in breach of the order of learned single judge, today, when the petition came up for consideration, affidavit came to be filed by the respondent stating inter-alia that repeating the said statement recorded in the order on oath, full stop, paragraph. It is further stated in the affidavit that the vehicle in question was obtained possession from the auction search agent and now has been handed over to the complainant on 27/1/25. The complainant acknowledged the return of the vehicle bearing number KA 02 MT 4234. It is what car?
Yes, XUV 700. XUV 700 car.
Vehicle, which is a car bearing registration number expansions. There is a substantial compliance, rendering the contempt petition not surviving accordingly disposed of.
Appearing for the complainant in this case, Your Lordship.
Pardon?
In this case,
Yes, what is the content?
Your Lordship, in this case, survey number 190, measuring 1.35 acres in Thoranagalu village was reserved as burial ground. In fact, when the accused, along with Jindal Southwest Steel Limited, tried to encroach that said land, a public interest litigation was filed before this honorable court. The order of that writ petition is produced as Annexure A. In the said writ petition, an undertaking was given that survey number 190 is a burial ground and it will be continued as a burial ground. Ink page number 10 is the judgment of this honorable court. The undertaking is found at ink page number 12, paragraph 1. And on that basis, a direction was also given by this honorable court, which is at paragraph 4. May I read, Your Lordship? Ink page number 12. The instant writ petition has been filed as a cause in the public interest alleging encroachment over government land insofar as survey number 190 in the revenue estate of Thoranagalu village, Sandur Taluk, Bellary district is concerned. It is acknowledged that the same is a burial ground and that it is still being used as a burial ground. It is submitted that there is no encroachment thereon. The instant factual position is apparent from the statement of objections filed on behalf of respondent number 4, as also the statement made to us in court today at the hands of Shri K. Dasappa, Tahsildar, Sandur. And on that basis, a direction was issued, which is at paragraph 4 of the said order, Your Lordship. In view of the above, we find no justification for interfering in the action of respondents. This was in basis of another survey number on the basis of the cause raised by the petitioners, except to the effect that the respondent shall be bound by the undertaking given to this court to the effect that
survey number 190 shall continue to be used as a graveyard for all intents and purposes. Now they are constructing a water tank in that burial ground. That is why we have filed this contempt petition.
They are constructing water tank.
Water tank in this burial ground in survey number 190. They appear to have filed an affidavit, a copy of which is not served on us also.
The land is now granted to Jindal, is it?
No, Your Lordship. Now they are no more party to this. The government, that is the accused,
Now under government itself.
it is a government land. After this writ petition, they did not interfere.
Where Tashildar has given an undertaking, my lords. Page 30, my lords. May I read, my lords?
Okay.
Shri K. Dasapa Tashildar Sanduru is present in the court. Person strongly refutes to the aforesaid assertions. He has handed over to us in court today photographs of the site in question depicting that the respondent number 4 has raised a boundary wall and also some construction in the area. The instant contention advanced at the hands of the Tashildar as also the factual position depicted in the statement of objections filed on behalf of the respondent number 4 believes that the contention advanced at the hands of the relevant concept petitioners. The allegation made in the said writ petition, my lords, that
Your
there
Lordship.
was an encroachment made by the JSW along with the authorities, my lords. But however, it is a government land, my lords, and it was actually a burial ground. It's till today has remained as a burial ground. And earlier itself, there were some construction put up, the old buildings or whatsoever, my lord, and there was also a water tank earlier itself. That water tank has been being renovated. The authorities are not putting up any new constructions. Your lordship may kindly see the photographs which I have produced with my complaints affidavit, my lords. Page number 7, my lords, annexure R2 of my complaints affidavit, my lords. Lordship, annexure R2 photograph, page 7, first photograph, my lords. That's an old water tank. There's only one water tank, gives water facility to the entire village for 18,000 people there. Now that water tank is in relative condition, my lord. Only a new construction work has been carried out as per photograph. Lordship may kindly see page number 9, my lords. It's only renovation work. We are not putting up any new construction. And 1 acre 35 gundas is the extent, my lords. In that 35 cents, 0.35 cents has been utilized. And it until today has remained as a burial ground. There is absolutely no violation by the as per the undertaking given the writ petition, my lords.
This water tank is in.
It's an overhead water tank, my lords.
Where
Which-
it is
which-
constructed where?
My lords?
Away from this area.
No, earlier itself, this water tank was existed in that survey number, my lords.
Here itself is one.
That water tank has been getting renovated. This is a public water tank which
Your
gives,
Lordship, so far as
So they are not discontinuing the use of.
no, till today has remained as a burial ground. It's only water tank has
Your
been put up to.
So far as this affidavit is concerned, I am served this copy today.
Whatever
I'll
other
make my
activity may, though,
submission.
we are not concerned.
No, there is absolutely no other activity, my lords.
Until they discontinue the.
And the nature of the land has not been changed. It
Your
still
Lordship,
remained as
when
a
the
burial ground.
undertaking was given before this honorable court, there was no mention of water tank.
No, that
The
is,
first time they are making, say, the entire 1 acre 35 guntas is
Your objection
burial
against
ground.
the construction of water tank,
Your
there is
Lordship.
no contempt. So
Your
long
Lordship.
as there is no discontinuation of the use of the graveyard.
nature of the land has not been changed.
So far as this affidavit is concerned, I'll go through this and make my submission. I've been given a copy of this
No,
only
no, you
now.
already made your submission, madam.
Your Lordship.
What was observed and directed by a single judge while passing order dated by the division bench by passing order dated 24th June 21 was that The respondents will be bound by the undertaking given to the court.
Your Lordship, the entire 1 acre 35
The
quintals
effect
is the
that
burial
Survey
ground.
number 190 shall continue to be used as graveyard for all the purposes, full stop. Today, in the present contempt petition, it is sought to be contended that the use of graveyard is discontinued and the land is, and on the land, a water tank is being constructed. So it may be true that at some end of the land portion, the water tank is being constructed as reflected in the photograph. There is nothing to show that the use of the land as graveyard is discontinued by the authorities. In the circumstances, it cannot be said that any contempt is committed by the authorities. The
Your
contempt
Lordship,
petition,
I may be given an opportunity.
meritless, and it is dismissed.
Yeah, I may be given an opportunity to give a reply to this affidavit, Your Lordship.
Not necessary.
It is for the first time they are stating about the water tank. It is not mentioned before the court.
Number 29, Mr. Subramania Bhatt.
I appear for the accused. Lordship, we have paid the remaining 50% amount also. I will file an necessary affidavit, Your Lordship. The order is, my Lordship, reinstatement with full back wages. Earlier, we have reinstated and paid my Lordship 50%. And we have also completed the remaining 50%, my Lordship. I will file an affidavit to that effect.
May I draw your lordship's attention to the order dated 9/8/2024, your lordship? On that day, they made a submission that 50% of the back wages, the benefits were paid and the complainant was reinstated. Thereafter,
So only 50% remains.
yes, your lordship,
Who
and
will pay?
it has to be
You are
paid by.
going to pay.
But as per my instruction, it is already paid, Your Lordship. But the complainant is disputing. It is a difference amount of rupees 15 to 18,000. If any difference, my Lordship, I will pay within 2 weeks and file an affidavit, Your Lordship.
While order dated 9/8/24 records that out of the back wages payable to the complainant, 50% has been paid and the rest was to be paid. Today, when the petition comes up for consideration, learned advocate Mr. So-and-so, the accused, appears through video conferencing to submit that he needs time, since according to his submission, the entire payment of back wages is made, full stop. On the next date, necessary affidavit evidencing the payment of entire back wages shall be filed, failing which a serious view will be taken. Stand order to
Your lordship,
5th of March.
my lord, any
We'll
day,
say a little earlier, 25th of February.
can it be first week of February, my lord, because they have stated that undertaken that 4 weeks, within a 4 weeks time, they'll comply the order.
Then now they are saying that entire thing is paid.
But that is only the oral submission. Let them produce any document.
17th
substantiate.
February, 17th February.
I am grateful.
Number 30, Mr. Chetan Kumar. 30.
Lord, the accused have already vacated the premises. I'll place it on affidavit.
Undertaking was given.
No, no undertaking was given. We have already vacated because they filed an execution. We were evicted from the premises.
What was the direction?
Lord, before the High Court, I took an undertaking saying that I will vacate the premises on.
That is what, monthly rent is paid?
Please, my lord.
Rent is being paid?
Please, my lord. Rent already has been, all rent has been paid.
So let the other side come, pass over.
Please.
Number 31.
31, please see
Yes,
the
I'm
order
appearing for
dated
the
17,
accused,
12.
my lords.
Please
We
see
have
the order.
preferred an SLP, my lords, question. We have preferred an SLP, my lords, question. My request, it may be taken up after 10 days. It may, likely to be listed tomorrow or day after is my instructions.
Going to be.
Please, that's what my instructions.
But your lordships had observed 3 weeks. How my lords?
Annapura stated that the SLP which is filed in respect of the order brought under contempt is likely to be listed within 1 week. Stand order. Today is 27th, 28th, stand order to 6th of February. Please.
Grateful.
This number 32.
7th February.
Please, grateful.
Number 32. Mr. Shankar C.
Apply for the complaint.
Even in this case, not matters before the Supreme Court, not it is an interim order also.
What happened? Interim order is
For the Supreme Court, Honorable Supreme Court, the interim order. The latest order sheet.
Can I make one submission? Interim order is only in respect of the position of the respondents, my lord, SLP. There is no stay of the,
This entire order before Supreme Court.
it's no, they are not stayed the entire order, my lord. Only this in respect of the respondent position, the Supreme Court has been passed an interim order. Last date of occasion, I filed the interim order also, I given the copy of this. This is subsequently, the order is produced subsequent, that is interim order is extended, that's all, my lord.
Here, not the order of status quo was passed. No, not the order has been continued till next date of hearing.
Yeah, orders. That is the interim order is continued till next date of it. This last occasion, the court has directed the government to whether to consider the name can be mutated subject to result of SLP. It has to get the subject to result of SLP, the names can be mutated. That is the last date of. Only my position has been protected, my lord, in the SLP order. There is no any.
I propose the previous order dated 19/9/24. Learned Additional Advocate General. Mr. Pradeep.
Yes.
Produced copy of order dated 9/12/24 of passed by the Supreme Court in SLP diary number 53577 of 24. In which the very order brought under the contempt jurisdiction of this court is under challenge. Wherever it could be noticed that the Supreme Court has passed interim order directing not to disturb the possession of the disputed property.
Respond.
In that view, we dispose it of.
No, ma'am, because this, the
that view,
divisional
contempt-
bench order is to mutate my names, madam.
The contempt petition does not survive for the present.
No, one second, my submission.
That is before
No,
Supreme
I
Court.
will keep my senior presence, madam. In a 1 week time, I be
And the
granted.
Supreme Court is seized with the SLP, this court.
No,
does
one
not
second,
have to
madam.
invoke
Please,
the
my lord, I request you.
contempt jurisdiction, the party shall abide by the orders which.
No,
will be
my
finally
request is,
passed.
my lord. See, I will keep my senior presence engaged with, he is in Supreme Court today, my lord. Kind of 1 week, 2 weeks time may be granted, but I will be make a submission on that, my lord. Please, my lord.
Number 33,
Lord, I am for the,
Sriram Reddy.
I am for the contempt, my lord. My lord, in spite of almost 6 months, it is the second round of contempt, my lord. Kindly go through page number 22, my lord. Ink page number 22.
So the direction, who appears? Nobody appears. Yes, yes. Yes, Mr. Sriram Reddy.
My lord, in spite of the orders passed by this, my lord, they have not complied. Kindly summon the concerned officers and let them file the affidavit.
Okay, I've seen. So there is already one round of.
Please, my lords, may I make some submission, my lords. Subsequent to order passed by this honorable court in earlier contempt petition, my lords. The POD has been conducted, my lords. Only the names of the petition has to be inserted in Pahani. Due to some technical error, my lords, everything has been getting computerized, my lords. Only that part has not been over, my lords. POD has been conducted, as done, and lords, there are series of communications been made, my lords. One document in Kannada, my lord, place it, my lords, where it says that. Pass it, my lords. Kannada, my lords, sorry. I'll read out the last portion, which is in vernacular language, my lords. I'm sorry, translated copy was not able to get it, my lords. I read out only the last paragraph, my lords. ಈ ಕಚೇರಿಯಿಂದ ಭೂಮಿ ತಂತ್ರಾಂಶದಲ್ಲಿ ಪಹಣಿ ಇಂಡೀಕರಣ ಮಾಡಲು ಸಾಧ್ಯವಾಗುತ್ತಿಲ್ಲವಾದುದರಿಂದ ಪೋಡಿಯಂತೆ, ಸೊ ಪೋಡಿ ಇಸ್ ಆಲ್ರೆಡಿ ಬಿನ್ ಡನ್, ಪೋಡಿಯಂತೆ ಕಗ್ಲಿಪುರ ಸರ್ವೆ ನಂಬರ್ 46ರಿಂದ 1 ಎಕರೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನಿಗೆ 453ರಲ್ಲಿ ಪಹಣಿ ಇಂಡೀಕರಣ ಮಾಡುವ ಬಗ್ಗೆ ಪೂರ್ಣ ಕಡತವನ್ನು ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಟ್ಟು ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಆಹ್ವಾನ ಸಲ್ಲಿಸಲಾಗಿದೆ. So it's partly compliant, my lords, because of the technical errors due to computerization, my lords. The name has not been inserted in the RTC. That will be done in some time, my lords. Grant some time, my lords, to say that. The POD has been completed, my lords. Earlier order was to comply with POD and duress, my lords. POD and duress has been over, my lords.
So what remains?
The names has to be entered in the RTC columns, my lords. Only the name has to be inserted.
But unless
Why you are not doing that?
unless my name is indicated in the RTC,
Once the POD and duress has been over, my lord, subsequently it has to be inserted in the Pahani column as the owner or cultivator of the land. Due to computerization problem, my lords, only that part is not renewed. Lordship, may kindly see for a moment page 20.
Why that part is not complete?
No, because of the computerization problem, my lord, there is some technical problem with regard to the insertion of the name.
The problem will last how long?
That I will complain in the earlier.
The problem will last how long? It's a mere consequential formality.
My lord, once POD and duress is over, my lords, it has to be entered in the RTC, my lord. That part has not been done because of technical
owner
problems,
of
my lord.
the property holder will be
Everything has been
interested in that part only.
But
He doesn't know that you conducted POD and duress. He will only see the reflection in the entry.
Subsequent to earlier order, my lord, passed by this honorable court, POD and duress has been done, my lords. That was the contention, my lords. We wrote para 1 of the order, my lords, at page 22. I require some time to enter his name in the RTC, that's all, my
We
lord.
grant time up to 5th of February.
2 weeks. Because of
10th February.
please, my lords.
Present petition, present contempt petitions will be next listed at 2:30 on 10th February, on which date learned national government advocate, Mr. So-and-so, they'll take instructions as to whether the claim of the respondent that the POD and duress is conducted is taken to its logical end by reflecting revenue entry in that regard in the record or not. If since this is a second round of contempt petition, if the entries are not done in the computerized form before the next date, a serious review will be taken by the court.
much obliged, madam.
Seal number 34. Ravi Shankar Shah.
Complainant. Around 2/9/2019, my lord, an application for, my lord, issuance of Lebanese sketch was made to the respondent authorities, my lord. Then, my lord, it does not consider for nearly 4 years. Writ petition came to be filed before this honorable court, my lord, and this honorable court, after, my lord, giving sufficient opportunity, my lord, at page 10, directed the, my lord.
What happened to your interim application?
My lords, in this, my lord, there are 610 grantees, my lords. Out of them, 410 individual survey has been done and certificate is issued, my lord. Remaining 200 has to be given, my lords. For that, I need.
No, last order says that interim application is filed for extension of time before learning single.
That too was not prosecuted, my lord. Till date, it was not, my lord, posted.
The difficulty is, my lord, without there being a Lebanese sketch, my lord, I cannot execute any registered document. My lord, I am running, my lord, for last 5 years to execute this document. And for this document, my lord, I could not do discharge my duty. 74 years, my lord, complainant. And my lord,
You are not able to discharge your duty because, why?
my lord, Lebanese sketch is, my lord, material for my lord, a requirement for registration of any of the document. My lord, I want to execute some registered document, my lord. 2019, I make the application for issuing this Lebanese sketch. 5 years have lapsed. Direction was issued in the year, my lord, 1 year, 3 months back. Till date, my lord, they does not issue this Lebanese sketch. It's a government requirement, my lord, that Lebanese sketch should be part of a registered document.
You said within 3 months.
That is, my lord, order dated, my lord, 24th August 23.
Order of August 23.
Out of which, my lord, out of 610, my lords, 410 has been done, my lords. Remaining 200 has.
We don't know the figure. We want compliance of this particular directive.
I have only approved this on court, my lord.
For some 4 weeks time, my lords.
No, you now who is going to do that? You can't be so lethargic in every matter. Yes, who is the authority to?
My lord, the Tashildar and the
Tashildar shall remain present to face the contempt.
I'll file a complaint affidavit.
Unless before the next date, the compliance of the direction is shown by preparation of the 11 sketch, the Tashildar shall remain present to face the contempt proceedings. Put up on 6th of February at 2:30.
Could it be 5th or except 6th, my lord, any other?
Except say 10th of February at 2.
Grateful.
We'll do the compliance, my lords.
You do it.
Please, my lords.
Because unless we are harsh, you are not going to do it. That is the only problem. We don't want to be harsh.
Or else let them dispense with, my lord, 11 sketches for registered document. My lord, this is where, my lord, everybody is put into difficulty, my lord. They say 11 sketch is mandatory, that does not issue for years together.
Does it take time to prepare a sketch? Or there is a lack of manpower?
There are total 610 grantees, my lord. Every individual survey has to be done, my lord. For that reason, my lord, time is required.
There's one judgment which I myself had delivered, which said that before grant itself, we have to do the podium durasti. That's what the law contemplates.
I'm aware of that.
But you are going on making grants without doing the podium durasti. They are unable to identify their lands.
Understand.
Lot of matters are, you are not able to identify.
We see
Merely because you don't prepare the sketch.
We see that it will be complied by next date.
Great. Number 35, Mr. Deepak Bhaskar.
Please, my lords, I appear for the petitioner. This is a petition preferred in public interest on account of the rampant commercialization of an area bearing ward number 58 at HAL third stage in Bangalore. By directions dated 15th March 2021, this honorable court had directed a spot inspection by the BBMP and the BDA. That inspection was subsequently undertaken, and the report filed by the statutory authorities virtually affirms the contents of my petition that there is rampant commercialization in contravention to the extant zoning regulations. Now, the latest affidavit by the BBMP, my lord, discloses their inability to enforce the zoning regulations because they fear a law and order situation. My lords will please have that. The affidavit dated 26th August 2024.
Now date, sir.
26.
824.
In fact, my lord, may I please pass on? There's a decision of a coordinate bench of this honorable court, virtually similar circumstances, where this honorable court was pleased to restrict any further commercialization in certain areas. Just pass this on.
Reply will be necessary. Who appears?
My lords, I appear for the BBMP Corporation, my lords.
It is filed,
Lords,
yes.
I may draw my lordship's kind attention to the statement of
Who
objections
has
that were
filed
filed
it?
on 12th
It is
December
filed
24. my
by
lords.
number 1. Yes.
Where it is.
Second set could. Let me know.
But in fact, throughout the pendency of this petition, the BBMP has said they have issued show cause notices to close down these establishments. The status of those show cause notices is unclear because these establishments continue.
Please.
Come to your paragraph number 3. Your objections.
Please. It is submitted that many of the commercial establishments which have not closed down have been running their operations for many years now. And when our officers, even with the support of the judicial police, have faced a lot of resistance and retaliation from the public against the closure drive, it is submitted that even as recent as 23/11/23, when our officers visited.
By this, you are stating that there is no law and order in the city, and there is breakdown of constitutional machinery. There is no rule of law. Sum and substance of your objection statement. And you have raised your hands that you cannot implement the law.
No, my lords. My lords, my only intention was to the requirement of a little more time to bring about the closure of those commercial establishments. That was only the intention, because my lords,
What were your ward engineers doing? What action have you initiated against them?
my lords, we have
Your ward engineers will approach any construction that is being put up, any new construction, right? We can't say thereafter what happens.
I bowed down, my lords, but then, my lords, we have been trying to take measures by even announcement in the auto rickshaws. We have placed placards. We have put up banners asking them to vacate all the commercial.
And your corporators also do the same thing.
My lords,
They don't notice it, is it? This is camouflaged or what?
no, my lords, we are only seeking a little extension of time, my lords, to implement the orders, because as and when we are going, my lords, the photographs would show that a large crowd gathers, my lords, and then there's a lot of push and.
Correct. It's your responsibility to implement the law.
My lords, most of them have closed down, my lords, and 248(1), 2, 3 notices have been issued, and actions have also been initiated legally, my lords.
If I may submit, the issue is twofold. The first issue is, my lord, at the BDA's footsteps, because there has to be a change of land use in accordance with the Town and Country Planning Act. There's no change of land use here. Residential land is being used for commercial purposes, and that's why the BBMP comes in, where they accord sanction plans and permissions for commercial establishments, even though there is no change of land use, nor is it a commercial area. So both the authorities, my lord, have shown complete apathy.
I would only want to refresh my lordship's memory, my lords, on the last occasion. My lordships had directed the colleague of the petitioner who's appearing now, my lords, approach the Honorable Lokayukta, my lord, that got time only to seek instructions on that regard. But nevertheless, my lords, we are taking steps to ensure that no new trade licenses are being issued, and the trade licenses which have expired are also not renewed, my lords. And 248(1)(2) notices have been issued, and legally we are proceeding, my lords, to ensure that there is a closure of the shops which are not closing, even though we have issued notices.
May I request then, in light of that statement, your lordships please record that no further trade licenses will be issued in this area.
Where there is violation, blatant violation, my lords, which is where the 40 feet and less road, and which is lesser than the 1/4 area of the building, my lords, only for them we are issuing, my lords, and not beyond, my lords. My lords, there is also a list that has been produced, my lords, way back in August itself, my lords, that no new trade licenses are being issued. That list has been placed, my lords. some more time, my lords, if granted, my lords, we can show the progress, my lords, as to how we are progressing in this matter. 248.12, where notices have been issued.
No, notices have been issued from as far back as 2017. Let them please place on record by way of an affidavit what the outcome of these notices are.
Outcome
Of the show cause notices, they claim to have issued show cause notices.
show cause notice is issued.
Show cause notices have been issued.
As far back as 2017, my lord, 8 years later, they say they are still in the process of issuing notices.
If I may
And
only-
those establishments to whom notices are issued, they still continue to operate.
May only draw my lordship's kind attention to page 14, my lords, 14 and beyond of the statement of objection. The show cause notices are dated January 24, January 23, August
Where from we
23.
get it?
Please, sorry, my lords.
Page
14 in the statement of objections, my lords, the annexure. Yes, my lords.
statement of objection.
Please. Full bunch of show cause notices have been issued throughout the year, my lords, identifying
I'll translation in none of the,
Please, I'll find
the
that.
show cause notice.
Yes, these are the show
What
cause.
did you do after
Lords, after
1923?
I'll
Just set tight by after it. Issuing show cause
I'll place it on record, my lords, as to the next steps that have been, undertaken, my lords. After the show cause notices, the next steps that have been undertaken, I'll place it on record. Some time may kindly be granted, my lord. We'll also ensure.
that we may grant, but my brother is entirely right that what kind of stand you are taking.
Lords, ground reality is what I would. want
Paragraph
to-
3 of the affidavit.
So in the BDA's affidavit, the BDA says we have nothing to do with this, it's the BBMP. BBMP says there's a law and order situation. So all of them are washing their hands off.
We'll pass the order. At least we can't tolerate such,
Some,
and this petition is not that omnibus. The list is given of the premises, shops and buildings which are constructed in violation of.
Please.
It is not general allegation.
lords, my only request is some opportunity of time.
We'll grant time, but then the present public interest petition. Flags the issue of commercial establishment in the city of Bengaluru that have come up in their construction and running contrary to the provisions of the master plan of the Karnataka Municipal Corporations Act. Master plans prepared under the Karnataka master plan and in breach of the construction regulations. Also, the petitioners, who are the petitioners?
So petitioners are residents of that area.
The petitioners who are the residents of the area have also provided the list of such buildings which are according to the case of the petitioner.
The list was provided by us, madam.
So even in the
List of provided you. Very good. The list provided, the list is all, the list appearing on record suggests that several commercial buildings stand in breach of the construction regulation. Paragraph. Learned advocate Mr. So and so for your BBMP.
Please.
Submitted that various so-called notices that suppose notices are received to such establishment, which are produced along with the statement of objections. The post of the respondent one shall file the English translation to the advocate of all the said so-called notices. Post of while granting time to the Commissioner BBMP to, in the above regard, the court noticed the following observations in the affidavit dated 10/12/24. It is not an affidavit.
Statement of objection.
Statement of objections. It is you have filed or your authority has filed?
Not the authority means.
Who has filed?
It's Dr. N. Bhagyalakshmi, Health Officer. So the verifying. I'd only request my lords that we will take necessary action.
See, there is no, we are not observing anything. I wanted to observe, but then this is really not, as my brother is rightly saying. You are just, you are a statutory
apologies,
body. How can you take such a step? That's the whole.
My apologies, my lords. We wanted to appraise this court, my lords.
You are before the High Court, Mr. And taking a stand that we are not able to do anything.
No, my lords. My apologies, my lords. The next paragraph would say, my lords, that we have continued to.
The abdication of your statutory duty and you are liable to be prosecuted for misconduct. Yes, we reject this affidavit.
How can a health officer sign this
But, sir,
from BBMP? What is her jurisdiction for violation of building bylaws or?
issuance of trade license.
Huh?
She is the authority issuing the trade licenses, my lords.
Trade license.
Please.
Issuing the
Trade license.
well, bring the notices, we'll see what to do, not observing anything. Please, send out to 19th February.
Please. Yeah.
Two representations, one is 8620. That is regarding the giving benefits of medical benefits to senior citizens.
Senior citizen.
Ashwini Kumar's case is being followed and court had direct passed the detailed order 7/12/2020 minute.
Lord, I'm filing a memo.
Use it 2019 2 SCC, what is it?
Madam.
632. Then what is the discrimination?
Please.
They are discriminated.
No benefits at all, Miller, senior citizens.
But there must be a scheme for senior citizens.
What has happened, Miller, is it is like this, Miller. If I belong to a particular community, I get some benefits. If I have certain benefits, Miller, I mean, financially poor, fine. But if in Kannada, Miller, we call it as Trishanku Sarga, Miller. We can neither die nor earn the. Such people, Miller, are a real problem, Miller. That's midway between, we can either get relief nor. The middle class, Miller, of certain communities, they are finding it difficult. And regarding office objection, my lord was pleased to pass an order, my lord, in similar matter, quarters. That office objection has been dispensed with, my lord.
Work. Even if we issue some directions, we'll be issuing policy direction. Unless there is specific instance of
No, of course, my
kind
lord,
of healthcare or discrimination or this is your motto.
please. No, one is filed by Mr. Rosario.
My lord, I am appearing in 36.1. This is an organization of senior citizens. Basically, my lord, for implementation of the act that has been brought into force in 2017, which contemplates certain plans, certain schemes that have to be done. That, my lord, has not been done. So seeking the enforcement of that, my lord, I am before this honorable.
My lord, today I'm filing a memo,
Yes.
my lord, where our honorable Prime Minister had launched a scheme on 29/10/2024 for senior citizens. My lord, operational guidelines had been issued. My lord, we have given a reply.
Friend can give a copy of that memo.
Yes, I don't have a.
Paragraph 28 onwards is relevant, minutes. Paragraph 44 and 51 onwards, minute. But I had given this quarter. All the judgments were given in the form of paper book.
I appear for the BBMP in the as eighth respondent in 10953 of 2020.
How many petitions? One?
Two petitions.
Two on
Two
that.
petition.
The second petition, my lord, on 1/3/2024, this honorable court had passed an order, my lord, regarding certain compliances that were required.
Second petition.
The second petition where the relief that is prayed for is at page 36.
Increase the monthly pension of whose month? This second petition prayer is to increase
Please, my
the
lord.
monthly pension. Whose pension?
For senior citizens, my lord.
Senior.
There is a scheme, my lord, under which they are paid pension. The Honorable Apex Court, my lord, in Ashwini Kumar's case said this is quite, it's very minimal. So there has to be a rethink insofar as that is concerned. In fact, my lord, this Honorable Court, in the order dated 28/6/2021,
In the second petition, reply is not filed.
no, my lord. Reply is required.
So these arrears are not paid.
My lord, some parts of it was paid, some parts have not yet been paid, my lord.
That pension is payable under some scheme.
Please, my lord, there was, please, my lord.
Where
This
is it?
Lord, the scheme I have not produced, but if my lord may please see the order dated 28/6, please. 28/6/2021. This honorable court, my lord, had issued a direction to the state government to place on record its stand on the question of increasing,
The question of?
on question of increasing the pensions. My lord may please see order dated 28/6.
That is seen somewhere. Yes, that you are right. It is here. Somewhere it was there.
Please, my lord, 28/6/2021.
So we therefore direct the first respondent and second respondent to file statement of objections, putting on record the schemes, various schemes which are available for the benefit of. It is filed or not?
My lord, replies are not filed, my lord. And even this compliance is not done.
My lord, the additional compliance affidavit was ready due to inadvertence. Our office has not filed it, my lord. I will file it. My lord may grant me some time with the latest, my lord, position. I will file it, my lord. It was ready.
So this pension aspect to be looked in.
I'll get the instructions. My lord, it was ready, but our office hasn't filed it, my lord. My lord may grant me some time. I'll get the latest position and then I'll apprise my lords.
Lord, may I submit, Lord? I'm in the first petition, Lord, 8620 of 2020. I appear for the fourth respondent, which is the regulator, IRDM, Lord, the insurance regulator. In this petition, the second prayer has already been rejected by this honorable court, Lord, by an earlier order. Only the first prayer remains, my lord, which is with regard to providing health care. I filed detailed objections. The Lord, allegation was, my lord, that there are no insurance policies available for senior citizens at all. Lord, I have placed on record policies which are available. There are 31.
Is for whom? You are for?
I am for IRDM, my lord, which is the insurance regulator. The regulator, only the regulator is made a party, my lord. There are 31 general insurance providers, my lord. List is at page 17 of my objections, who are supposed to provide policies. These are all pool-based policies. Basic policy, health policy, my lord, are available. If they want, my lord, add-ons, they have to pay a higher premium. The allegation is that, my lord, policies are not available at all for senior citizens, my lord. That is sought to be cleared by filing objections and pointing out that there are in fact policies which cover the basic risks so far as senior citizens are concerned. Para 11 of my objections, my lord, provides details of such policies. Therefore, my lord, the main allegation that there are no policies at all for the senior citizens, that may not be correct, my lord, is what we have tried to place on record.
Is your memo today?
My lord, the Honorable Prime Minister, my lord, had launched
No, sir.
What do you say?
They have only sought for instructions from the government. My lord could kindly see. The directions from the central government is awaited in this regard. In the memo itself, they admit.
My lord, please see the date of that scheme, my lord, 4/11/2024.
Yes. They have still to get a reply and they have not placed that any reply or received or not.
Writ petition number 8620 with writ petition number 1953 10953 of 2020. While the writ petition number 862020 relates to extending the medical care and medical infrastructure to the senior citizens in light of the directions issued by the Supreme Court in Ashwini Kumar versus Union of India, 2019, 2 SCC 636 bracket 1. From other petition, in the other petition, the prayer is made
9 prayers then.
to direct respondents number 1 and 2, who are the Union of India and State of Karnataka, to increase the monthly pension as directed by the Supreme Court in Dr. Ashwini Kumar Supra. It is also the prayer to direct the Director of Social Security and Pension, State of Karnataka, to release the pension amounts due to the senior citizens since January 2020.
But prayer D won't survive. Prayer E, my lord.
It was sought to be submitted that by not releasing the pension payable to the senior citizen, their right to seek the right to have the medical facilities, medical treatment. Curtailed. In the first petition, replies are filed? Not filed. Neither in the neither of the petition.
My lord, I have filed, my lord,
Filed?
statement of objections I have filed in the first petition, my lord, on 4th April 2024.
In the first petition, it was stated that the state of Karnataka has filed
R4 has also filed.
statement of objections. Who is for Union of India? You are?
I appear for in the connected matter, my lords. In the connected matter, I appear for the
I
union.
appear for Union of India in WP 8620.
Second matter, I appear for the union of India.
Connected is first matter, 8620.
Lords, first matter, my.
I appear for Union. I appear for R1 in 8620, my lord.
Have you filed the counter?
Yes, I have filed statement of objection and further additional statement also I have filed.
All right. In writ petition number 8620, the counters are filed. However, no statement of objections are found to have been filed in other writ petition number 10953 of 2020, in which the prayers are made regarding the payability of pensions, public areas of pension to the senior citizens. The respondents are directed to file their counter and complete the pleadings on or before February 13. The
Yesterday, I was in Shimoga in de novo. My case of contempt case is dropped without my hearing, and I do not understand the thing. I filed this memo for reconsideration.
ಇಲ್ಲಿ ಲಿಸ್ಟ್ ಆಗಿತ್ತಾ?
List ಇಲ್ಲಿಗೆ dismiss ಆಗಿರೋದು court or 4 ಅಲ್ಲಿ. I was in de novo in Shimoga, as per the orders of this honorable court. Kindly, my lord.
which matter? Not before this. We have not done anything.
My lords, it is,
So go before Registrar Judicial. We can't do anything
my lords.
unless
the
there is a
case
matter
is-
before us.
The case is held here only, and it is listed in this portal,
Which matter?
CCC 448 of 2023. It's myself against LIC of India.
Contempt. Not before this. Contempt was before another court, Mr. Party in person. So go before that bench or whatever remedy you have on administrative side.
And I went and approached today morning, and it was only for that yesterday it is posted there, and the rest of the things has to be carried out in this court hall. That is what they said. So I have come here again.
Which court? We do not.
Portal 4.
We can't, this is not the public platform to hear the
Yes, my
oral
lords.
complaint.
I am also
You file the
confused.
proceeding, we will deal with.
I am very much confused, my lords.
We are also confused before because of your mentioning.
I'll file this
Matter
memo.
which is before other court, not before this court. We are not here to go on hearing the complaints from the party in persons. You file your proceedings and we'll deal with it.
Obliged.
The matter belongs to different court, not before this court. So there is no point in wasting the time in mentioning. You are well versed with the procedure, appearing in several matters. If the matter doesn't belong to this court, you don't mention. in the open court. You have your remedy on administrative, file appeal, file revision, file review, correct?
Come for office objection.
62.
Making the submission on behalf of the petitioners.
So on time.
But there's only one office objection. We have said that may be dispensed with, the office objection. The office objection says, it's survey numbers are mentioned, the map, The office is asking us to give the typed copy,
All right.
That may be dispensed with.
Office objection regarding type copy is dispensed. The appeal may be listed.
There's no delay, maybe posted for
May be
action.
listed when? 13th February.
Remember to pass the.
With the call, there is not called out and you are passing it over. No, unless it is called out, how can it pass? There is nothing passed by to be passed. Yes. With the call out, right? You called it. Pass over. Why pass over?
It passed over, needs to submit in that passed over.
Pass over some other day, tomorrow, day after tomorrow.
There is a simple
Pass
matter.
over. Pass over.
The 230 matter, seal number 68. Keshav M. Datar. And with serial number 5 and 59.
In this matter, my lords, just pray for a week's time, my lords.
14th February.
Like,
If all three could be called out on the same date and connected, my lords. If all the three matters could be called out on the same day, then
Which one?
seal number 59 and seal number 5.
pleasure.
Grateful.
Number 69. Mr. Dhananjay Kumar.
My lords, it's the matter pertaining to listing of sand blocks for e-tender. Last time your lordship were of the opinion that it's a policy decision of the government and cannot be interfered with.
We have no opinion.
My lords, my submission is that now a 7-member committee was constituted. They inspected the site, but it was not listed for tender. All the other 6 properties that were listed for tender were adjacent to this on the same river. Now our representation may be considered because they have not stated any reason as to why it was not included. No reason is stated as to why it was not included, my lords. I had already made all the preparation. I had leased the land to construct a stockyard. There are 20 people employed by me. I have rented out boats. And the site inspection was conducted, but it was not listed.
Same 10 block.
Yes, my lord.
Without considering the 10 block of Falguni River.
Yes, my lords.
So you don't have any right. Why it was adjourned for withdrawal?
Yes, my lord, because my lord observed that since the government has decided not to include that block, my lord, they couldn't force us to include the.
Yes, my lord, but my submission is that it is a policy decision of the government, it's true. But when a policy decision is being taken, shouldn't the government consider the opinion of the officers? 7-member committee was constituted. They visited the site, they inspected and identified it, but it was not listed. Let them produce a reason as to why it is not listed, my lords. Because all the other blocks that were included were on the same river. Now, one condition is that you can only bid if the sand block is in your taluk. It's not listed. So I cannot be a bidder also. No, my lords, let them consider my representation. Let them inform why it's not included.
Then you withdraw. You want to consider it. Or want your representatives to be considered, then withdraw it.
Well, it's the scope may be limited to just considering my representation because to know a reason as to why it's not listed.
Are you withdrawing for going before them with representation?
No, Millards, I just need to know a reason as to why it's not listed.
Pardon?
I'm aggrieved due to the fact that I don't have a reason why it's not listed, though it's identified.
No, are you inviting order or you are withdrawing for making representation?
An order may be passed, Millards. An order may be.
Tomorrow will again decide.
No, Millards.
Yesterday you wanted time to decide whether to withdraw or not.
As well as I had taken instruction. He has already invested huge amount of money to create a stockyard, to hire people to buy boats. He's a traditional sand miner who is working for 20 years in the same field.
This is your maiden matter? First matter?
No, Millards.
How long you have?
2 years, Millards.
2?
2 years.
2 years. Reasonably. 2 years is nothing in this.
Yes, Millards.
So come with a good, better, strong matter. You don't have any enforceable right.
Yes, Millards.
Are you withdrawing or shall we pass the order?
Millards, maybe passed or I'll get instruction from my senior.
Who is?
Dhananjay Kumar. I'll get instruction from my senior as to.
From your senior?
Yes, Millards. Maybe passed over.
So madam is not your senior?
No, Millards.
When? 4 o'clock?
Yes, Millards.
3:30?
Yes, Millards. Anytime, Millards. I'll be here. Okay.
Crossover matters. Seal number 2, Mr. Adi Narayanappa.
Number 2. This is interim order. Interim order. We keep ourselves away from interim. In contempt jurisdiction, and also in LPA jurisdiction, unless there is a finality in some way. There is no gainsaying. Come and learned advocate Mr. So and so could not dispute the factual position that the order brought under the contempt jurisdiction dated 24 June 2024, passed by learned single judge, is an interim order. In the pending writ petition paragraph, learned single judge has issued notice fixing the next date of hearing, and in the meantime, stay granted. Full stop. The order is not only interim, but without hearing the other side. No right of any of the parties are finally crystallized. Therefore, this court is not inclined to invoke the contempt jurisdiction to entertain the present petition. Full stop will be open for the petitioner to work out rights and remedies in the proceedings of writ petition, where the controversy is at large to be considered on merits. In the aforesaid, dismissed as above.
Seal number 6, Mr. Subramania Bhattacharya.
Notice written on 25th of February.
Seal number 9, Mr. Satish K.
The order of coordinate bench of this honorable court is at page 17, lecture 8. Operative portion is at 23. Matter pertaining to compassionate appointment. Direction is to consider my representation at page 23.
Notice written on 25th February.
Seal number 13, Mr. KB Monesh Kumar.
Let's time for the appellant in this case.
Respondent.
Let's matter where the learned single judge has been pleased to dispose it of, please, my lords, that the FIR will be reckoned as 2.25, where the permissible FIR is only 1.75. Aggrieved, please, my lords, I am before my lords. That's the note. We have issued an endorsement, please, my lords, annexure N, my lords, page number 96. As per the endorsement, please, my lords, nowhere we state that the road in question, please, my lords, is in excess of 13 meters. We are all along saying, please, my lords, it is less than 12 meters. 11.3 to 11.8, please, my lords, is the road width. Now that, my lords, is based on what the petitioner would do, writ petitioner would do is, my lords, he would put his compound, please, my lords, a little inside to ensure, please, my lords, that the road width only in front of his house premises, please, my lords, will be excess of 12 meters. Now that, my lords, learned Singh holds, please, my lord, that the proper road has not been formed. So wherefore we will give them the benefit and orders that, my lords, the FAR should be considered, my lords, at 2.25, where FAR permissible is only 1.75. We have inspected the premises, my lords, and we have issued an endorsement. That endorsement was under challenge. Endorsement, my lords, is at Annexure N, my lords, page number 96. This is all the case. And our objections, my lords, we have measured it and we have said, my lords, it is 11 to 11.85 meters at page number 101.
If it is taken at 12.2, it will be 2.25.
2.25, my lords. There is no road width of 12.2, please, my lords. In fact, our objection statement is very clear. It is only, my lords, at page number 96. And what we have stated, please, my lords, in our objections, page number 101 is, it is 11 to 11.85 meters. The road width is 11 to 11.85 meters.
My lords, may kindly see, my lords, Annexure J. Annexure J, my lords, was a disputed document that was impugned before the learned single judge. My lords, may kindly have page 98, my lords, paragraph 3. My lords, even before rejecting my application, my lords, they find that the property abutting the road of the respondent, in fact, my lords, has got 12.220. My lords, may I read para 3, my lords? Para 3, page 98, my lords. But then the location was verified in respect of the proposed revised plan, approval with additional FIR submitted again. As per the reference, width of the connection road to the said property is not parallel, but different widths, and the width of the road adjacent to the property on the left side and right side of their property is so and so. It is observed that there is a small area in front of their property has been reserved for a road as the enclosure of the wall has been built. So in reality, only 12.220 meters is in front of the road. It will be a wide road. It is observed that the width of the said road is limited to the property only. Now, my lords, this is the reason, my lords, why learned single judge, my lords, in fact, directed the authorities, that's the appellant authorities, to inspect the road and give a detailed report, my lords. My lords, in fact, my lords, the report has not been filed by another train. My lords, they go into the place, they observe there are about 11 apartments that are constructed on the very same stretch of the road. Now, my lords, it's also observed, my lords, that the width of the road is varying from one point to another point. Now, my lords, as regards the property of the respondent is concerned, my lords, it faces at 12.20 meters, my lords. 12.20 meters. That is the observation, my lords, I just read.
Width of the road.
Correct. Now, my lords, the criteria, my lords, is for, it should be a 12-meter road. If, my lords, I am entitled to 2.25 FIR. Now, my lords, this is the reason, my lords, at paragraph 10, the learned judge, my lords, looks into the report and then, my lords, passes an order. My lords, may I just request my lords to take page 17, my lords. My lords, I'll read from page 16, para 9, my lords. A perusal of the sketch has been produced by the road indicates that the width of the said road measures differently at different places, ranging from 10.46 meters to 13.88 meters. Thus, it is clear that the very same road has different measurements at different places. However, differentiation between the measurements is not that much, except in two places, where is it 10 meters in most places, it ranging towards 11 meters up to 13.88 meters. The benchmark is for the purpose of construction of FIR is in the present case, which is 12 meters wide road. Thus, the differential that is sought to be pointed out by the corporation is between 11 to 12 meters in depriving the petitioner of higher FIR, which has been granted to other owners situated on the very same road. The contention of so-and-so is that there is an artificial widening of the road of the petitioner. The shifting of the compound wall would indicate that in the front of the property of the petitioner, the road width is 12 meters. Whether it is artificial or not, the fact remains that the width of the road is 12 meters or more. The width of the road measuring different at different locations. Other owners and properties situated on the very same road being made available for the benefit of 12 meter, I am of the considered opinion that if it is accepted for argument, sake of petitioner has shifted the compound wall, artificially widening the road in front of their properties is 12 meters. Such situation would not deprive the petitioner of FIR 12 meters. Therefore, my lords, the learned single judge, my lords, gets a report, finds out, my lords, that it is 12.20 meters. Now, my lords, my property, my lords, abates at 12.20 meters. My lords, it is the authority, my lords, which has to maintain the uniform road. They don't do that, my lords. My lords, can they, my lords, deprive me of this FIR is the only question, my lords, that was considered.
I'll answer that question. These are all 110 villages, please, my lords, which have now come into the ambit of the BBMP. There are no proper roads. We'll have process of formation of the roads is going on, please, my lords. Now here, my lords, there's absolutely no road, please, my lords, which measures excess of 13 meters. It in excess of this, my lords, the requirement. It is only measuring, please, my lords, 11 or 10. It is less than, please, my lords, 12 meters.
However,
He has shifted, please, my lords, the compound wall.
how have you treated similarly situated people on the same road?
That has come up only for consideration now. That is not for subject matter.
No, you have to answer it.
Please, my lords.
How have you treated
Please, my lords.
similarly situated
If it is
persons
in
on the
excess-
same road?
No, not on the same road. If it is in excess of 12 meters,
No,
my lords,
that is
I will,
the-
that,
that is-
aspect I will have to ascertain. But my respectful
No,
submission is,
that is the specific finding of the learned single judge.
please. But our our contention, not before the learned single judge was, it was nowhere, please, my lords, in excess of, my lords, the requirement. It is only, please, my lords, it is 12, less than 12 meters. He has shifted the compound wall, please, my lords, to make it, my lords, in excess of, it measures only 12.2 there. All along, please, my lords, the road is measuring only, please, my lords, between, my lords, I have, our endorsement is very clear, my lords, at annexure J. It is only measuring 11.85 to 11 meters. The entire width of the road is measuring only 11.5 to 11 meters, only in front of the property of the petitioner. That is recorded by the learned single judge that he has shifted the compound also. Backwards, my lords, to extend, so that there will be more road width, and my lords, it will fall for consideration for higher FIR. That is recorded, my lords. The virtual, please, my lords, the learned single judge hold, please, my lords, that I am of the considered opinion that even if it is accepted for argument's sake, the petitioner has shifted the compound wall and artificially widened the road in front of his property to be 12 meters. Such a situation would not deprive the petitioner of FIR of 12 meters width. But our endorsement is very clear, please, my lords. It is only, my lords, varying between, my lords, 11 to 11.85 meters. Annexure J.
Let's to answer this question, my lords.
That is our report, my lords. We have reported to the learned single judge also.
See, the writ petition has gone against you on the ground that there is no uniform width of the road throughout. Number one, the width of the road keep varying before different plots of land.
Please, my lords.
And for similarly situated persons, where the road width has been more than 12 meters, you are given greater FAR. This is the specific finding of the learned single judge. Now, you cannot treat him differently.
Please, I'm sorry.
Okay. Probably you're required to file an affidavit to state, clarify this particular position.
Please.
If you have treated him differently, then the order has to sustain.
What we have said is very clearly.
And what is the interpretation of 11.2? Let us see.
In our page number 96, my lords, may kindly appreciate, please, my lords, our endorsement that has been issued. Kindly, for one moment, my lords may appreciate. Nowhere we say, please, my lords, is in excess of 12. All along, my lords, we have measured it and said the entire road width measures 11 to 11 point, my lords, 11.85 to 11. Only in the, my lords, the petitioner's premises, my lords, it is 12 because he has pushed the compound. He has removed the compound wall and pushed it a little inside to make it look, please, my lords, that it is made up. 12 meters is made up, my lords, by the petitioner. That is what we are respectfully contending. That is the endorsement that we have issued. With the others, my lords, I'll have to ascertain, please, my lords, from the authority as to whether they have really issued it or not. That, my lords, has come up for consideration. Now, I'll check with my authority. But with regard to the endorsement that we have issued, we have checked up, please, my lords, with the road. We have measured it, and the entire stretch measures only, my lords, we have clearly indicated, my lords, at page number 96. My respectful submission would be, it measures only between 11.85 and 11. If it measures between 11.85 and 11, short term, my lords, less than 12, they would be entitled for 1.75. It is in excess of 12, please, my lord, they will be entitled for an FAR of 2.25. So that's a huge difference. Now, the road width itself doesn't take, please, my lords, the pressure as it stands. My lords, if the more number of houses are built, my lords, it will be impossible for us, please, my lord, to provide the facility. Going ahead, my lords, it will be disastrous for us. Water, power, my lords, so other consequential benefits every citizen will have to, my lords, be provided with. Now, my lords, with this higher FAR, please, my lords, which is only made up, my lords, for the purpose of, my lords, this created, my lords, only for the purposes of, my lords, achieving higher FAR, that situation should not be permitted, is my respectful submission. And with regard to my lord's question, my lords, I will ascertain, my lords, if they have really done it, and I'll place the material before
Sorry, my lords, is falling short of instructions. Before the learned single judge, my lord, they filed a report.
Yes.
They, in fact, my lord, what, yes, sir, you have not made it a part of their writ appeal. My lords, then, my lords, in fact, my lords, they filed a report. They also, my lord, said, my lords, there are several other properties where they have given the similar FIR, my lords. All these, my lords, are part of the record before the learned single judge. In fact, my lord, the sketch of the road was also produced.
If that be so, my lords,
This endorsement was before learned single.
Yes, this endorsement was page number 96, my lords. That was placed before the learned single. That was what was challenged.
My lord, the sketch like this was produced, my lords, before the learned single judge by the corporation.
File affidavit.
Please, my lord.
File additional.
Additional?
Affidavit.
Affidavit. I will do that.
My lords, may I request, my lords, the records be called for because
Only you to reassert that it is uniformly.
Yes, the whole topography, my lords, we will produce it before my lords.
my request, my lords,
And you have to answer this
the records
specific
of the-
query.
Please, my lords,
Has
this
he-
query as to other places, my lords, whether they have granted higher
Others have
FAR.
been treated.
Yes, my lords, if they are differently treated. And that, my lords, I will ascertain, my lords, from the.
And you also can file whatever.
My lord, it's the part of the single judge file, the writ petition file, my lords. They in fact produced it. The learned judge, my lords, called for all these details, my lords. And my lords, one more undertaking, my lords. Now, my lords, my property, my lords, abates 12.220. My lords, I give an undertaking, my lords, I will not exceed that. My lords, now my property, my lords, are given according to them, abates, it measures about 12.20. I will not encroach upon that road area. Why would I do it, my lords?
The question is higher FAR, not.
No, that is not their contention. Their contention is you have taken back the compound wall a bit
Shifted it.
behind.
My lords, that-
So that,
It looked 12.2 because the entire road is, my lords, 11.3 to 11.8. The
Let's-
whole
let-
road measures 11.3 to 11.8. That is what we placed the material before the learned single judge.
My lord, it measures 13 meters at one place, it measures 15 at other place, 10 at other place. But we have, in fact, the sketch was produced by the BBMP themselves, my lords. In fact, I'm carrying it. My
I think
learned friend,
probably we
unfortunately-
need to look at your sale deed also.
Yes, my lords, all
So-
that,
Now, please, let them produce it.
North, south, east, west, how much it is.
Yes. In fact, my lord, the court commissioner can be appointed. My submission would be that any court commissioner can go there, visit the spot once again and do the whole, my lord. I
First
leave it-
you file this affidavit.
I will file the affidavit.
First you file the.
I'll file it.
When?
Lord, 2 weeks.
18th February.
18th.
My lords, my request, the writ petition file be called. Writ petition file, my lords. Because, my lords, in fact, he is also not in possession of so many documents that were filed before the writ court, my lords. Could it be called, my lords?
Pardon?
The writ file, my lords.
We'll see.
Number 30 to Chetan Kumar H.
For the complaint, please, my lord. I apologize. In the morning session, I was held up in another court.
Vacated.
My lord, my submission is we took possession of the property by the process of the court by filing execution petition. The accused did not voluntarily hand over the key. That does not absolve him of the act of committing contempt of court because he has given an undertaking that he would vacate it on or before 28th of February 2024. And despite passing of
Admittedly, the possession of the property.
property is obtained, my lord, I cannot
There.
deny that. I've obtained it in the, but the fact is he did not voluntarily hand over the key. I had to file execution. I had to take the officers of the court and obtain possession after he resisted. And then after the court officer said, you cannot act in such a manner. And then after that, he handed over the key. But the fact remains that he did not hand over the key. After giving an undertaking to this honorable court, stating that he would hand it over on or before 28th of February 2024. Prior to that also, my lord, he had given an undertaking that he would pay arrears of rent. After that, he violated that undertaking also. I had to file a contempt petition before this honorable court. And after the contempt petition was disposed of, he gave 2 checks to me and he immediately dishonored them. That is the conduct of the accused. Thereafter, he has given an undertaking that he would vacate it on February 2024. He did not vacate it. I filed a contempt. He didn't do anything. He has not even filed an affidavit stating how this fact would come inure to his benefit. He has not even submitted an apology to this honorable court. My submission is that conduct itself demonstrates that the accused is contaminacious in nature and deserves some sort of reprimand from this honorable court.
Lord, I'll file my apologies affidavit.
The directions of learned single judge in order dated 14th December 22 included handing over of possession for the appellant to the respondent and also regarding payment of monthly rent. The present petition came up for consideration today. It is not in dispute that the rent was paid and the arrears are also paid.
Please, madam. They themselves have stated, we have given deal.
As far as possession is concerned, paragraph. As far as possession is concerned, the possession admittedly lies with the applicant. Possession of the premises admittedly lies with the petitioner here. Arguments sought to be raised as to whether the respondent handed over the possession and the keys voluntarily or possession was taken over by the petitioner on his own. Full stop. This rival submission is in the nature of a word against word. Full stop. When the possession is already with the petitioner, comma, the contempt stands purged. The court is not inclined to go into any other factual aspect. Full stop. The contempt proceedings are closed.
Much of them.
And disposed. This is number 37 to Bhanu Prakash Viji.
Pardon?
Retired. Number 3, madam.
Given the NOC, my lord.
What is it about? You are for the petitioner. EIL.
Yes, ma'am. Here are the appointed as the additional advocate. Banu Prakash appointed as the additional advocate. So we given a notice.
Learned advocate, Mr.
And
appears to submit that he is retired from the matter and no more appears from the petitioner. It was also stated that the no objection is given for engaging another advocate. Full stop. Be as that it may. So much. 4 weeks time is granted to the petitioner to make alternative arrangement. The not the learned advocate who is presently on record shall intimate this aspect to the petitioner by registered diary post and shall place the communication on record before retiring. You do it, it is your response, not we are. You can't run away like this. You intimate your client that 4 weeks are granted. We are keeping it on next to the petition to come up next on 11th March. Address a letter and place copy.
Case number 38, Padmanabhan.
for complainant, ma'am. Not
Permitted withdraw.
We have complied.
Learned advocate, Mr. Padmanabha R.
We have complied, my lord. Compliance is also
No,
filed.
madam. Kindly present the order, my lord. 23/8/2024 at
Okay,
serial
what
four,
is
my
this?
lord.
I
Their own
thought you are
submission by-
filing the withdrawal. No?
Their own submission made by them. Lord. The subsistence allowance is on under way. Considering recorded their own submission, not this case has been adjourned. Not that paid today the subsistence allowance not paid, not neither the subsistence allowance not paid, paid or revoked the suspension.
The order of the Learned single judges at page number 15, my lord. The direction is to consider the representation. Lord, the matter was
Not
placed
done.
before the syndicate.
Contempt of court is alleged in respect of the following directions. In particular, what is directed in paragraph 5. In order dated 8th August 2023, passed by a single judge while disposing of the writ petition number 15698 of 2021. In court paragraph 4 and 5, page 16. So submitted that the subsistence allowance is not paid. Therefore, there is a breach of directions. First of the direction paragraph. In paragraph 5, only required the respondent to make to decide the representation. Only required respondent 1. The Directorate of Sanskrit Education to decide the representation of the petition. Full stop. The paragraph memo dated 3/9/24 is filed, with which copy of the order of endorsement
Yes.
is produced. Full stop.
Not endorsement, but it is proceedings of the syndicate.
Resolution. Passed in the meeting of the Karnataka Sanskrit University dated 14/8/24 is produced which is in vernacular. Full stop. The translated copy as produced reads as under. Court. Page 4 of the blue flap. The above resolution decides the resolution, decides the representation. Therefore, it can be said that the directions of learners in
Respectful submission.
is complied.
We are passing the resolution, madam.
No contempt. Contempt proceeding does not survive. They are disposed.
Great.
We are passing the resolution, my lord. Fruitful representation not full. Learning single judge order. They won't, there's no communication made by the.
If the petitioner has any grievance about the resolution or passing thereof, it is open for the petitioner to institute independent process in accordance. For which this court does not express any opinion on merits.
Grateful.
Seal number 39.
As of the sixth respondent. What's in the delay of 175 days. Appearing for the appellant is 39.1. It is written in 991 of 24, where there is a delay of 179 days. Because R11 to R15 are represented. I have to take notice to
Madam.
R6 to R10.
In first matter, my lord.
R5 to R10 and R16.
In first matter, my lord, service of notice on R5 is.
No, as so far as the first matter is concerned, there is an order, interim order operating against me. So I intend to argue the matter, man, as far as the vacating of the Indian.
ಇದರಲ್ಲಿ ಎಲ್ರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ?
What is this?
This is a writ petition filed against the order of the land tribunal by the persons who say that they are not interested in the proceedings. And the government filed objection stating that the writ petition is liable to be dismissed. The writ petition was dismissed. Government is aggrieved. Having sought for dismissal of the writ petition, the government is aggrieved and they have filed an appeal. They said the writ petition is liable to be dismissed in limine. Your Lordship may kindly see the counter filed by them, Mr. Peja. Just Your Lordship may kindly turn to page 281, counter filed by the respondents 2 to 4 who are the appellants before this court.
But just 3 sentences.
No, I'm on my legs, please, please. Let me complete it, then you can argue the matter.
See, from the beginning, it's not said.
I don't like interference, please. As a senior advocate, you must maintain the decorum. When I'm arguing the matter, when you made a submission, I did not open my mouth. Now, Your Lordship may kindly see the counter, they have filed it. At 281, the government has filed the counter. Kindly turn to page 281. Including the school, files a objection to the counter to the writ petition.
Yes.
At page 281, then Your Lordship may come to para 2, the next page. The first page is the prayer that is sought for. The second page, the second para, it is submitted that the writ petition filed by the petitioners are not maintainable either in law or on facts or in law, and hence the same is liable to be rejected. And then Your Lordship may kindly turn to para 8. 285, para 8.
You are for state.
No, he is for the state. That is to.
State has filed the
You
appeal,
are
my
the
lord.
appellant.
Please. My lord, the service on respondent number 5 is not complete, my lord, in this matter. On 24/9/24, my lord, parties have been directed to maintain status quo in this matter, my lord, an order of status quo, because they were about to put up construction, my lord. A detailed order was passed on 24th September.
I have
directing
been in the
parties-
litigation for half a century, my lord, more than half a century.
Let the service be completely done.
And Your Lordship may kindly see the contention of the stand of the this one of the state at para 8. Your Lordship may kindly see.
Right.
It is submitted the 285 para 8. May I read, Your Lordship? May I read? It is submitted that the petitioners are substantially contending that the lands in question are government and that the same was earmarked for primary by school. It is submitted that the petitioners, even though are claiming to be the citizens of Battarhalli village, Bidarhalli Hobli, Bangalore, East Taluk, instead of preferring a public interest litigation, since for the fact that they are impleaded before the third respondent had contested the matter and has now preferred the writ petition. So their contentions are twofold. The government contention that the writ petition is not maintainable. Then second contention is the sort of the nature of a public interest litigation is not maintainable. Now, whatever the contention was accepted by the learned single judge, is the writ petition holding it's not maintainable, holding the petitioners are not, have no local standing. Now they say they are aggrieved. Your Lordship may kindly say the writ petition, the format of the writ petition, Your Lordship may kindly, I'll take Your Lordship to 2 paragraphs. Now kindly take the writ petition, my lord. It starts at page 76.
But who is not solved?
Respondent number 5, my lord. It's a legal heir of the original grantee, my lord. So therefore, that we will complete, my lord. In the meanwhile, the second matter, notice has not even been ordered, my lord, in both the matters.
Then we will see, no? That the service complete. The endorsement on the board shows that this number 6 has remained unresolved. Therefore, the appellant side shall take steps to solve this one. You want press notice?
My lord, the respondent number 5, we have taken steps on 3 occasions, my lord. In addition to the court notice.
5
not-
or 6, who is not solved?
Respondent number 5, my lord.
5, sorry,
6,
5.
my learned friend appears, my lord. 6 legal.
You'll take press notice or what?
Fresh notice I will take, my lord. In addition, my lord, the counsel who has represented in the writ petition, liberty may be reserved, my lord, will serve on him.
Press notice.
Thrice we have taken steps, my lord.
Available on 14th March. In addition to normal mode of service, in addition to the service permitted by hand delivery, from a learned additional government advocate is permitted to serve. Say it is 115 to the council, to his counsel, who appeared before learned.
My lord, my represent, my
39
submission has not been
39.1
recorded, my
lords.
lord. I am seriously affected by the interim order. Kindly vacate the interim order, my lord. That's my speech. The writ petition is not maintainable. The learned single judge has held the writ petition is not maintainable. The government opposes, they say in the writ petition. Interim order has been granted in the writ petition.
Next day.
39.1, my lords. Notice, I have to take out notice to R5 to R10 and R16
49, notice it, R5 to R10.
and R16.
R6.
Lords, 1 to 4 by the government, my lords.
I'll accept notice, my lord. Respond number one.
Notice on behalf of respondent 1 to 4.
1 to 4.
In addition, my lords, I may be permitted to serve it on the councils appearing before the learned single judge, if any. Lordships, grateful.
Mr. Subramania, but
I appear for the complainant in this case, my lord. My lord, Annexure C is the order passed by the learned single judge, wherein there was a direction to consider the representation given by the complainant within a period of 3 weeks. In the said representation, there was a request to the authorities that the corpus fund which was deposited in the authority, with the authority to, there was a resolution, my lord, to deposit 1 crore rupees as a corpus fund in the Kolar Urban Development Authority. And it was decided that the interest accrued from the said corpus fund will be utilized for the pensionary benefits of the retired employees. The said corpus fund was withdrawn by the second accused, so that the accused complainant made a representation to deposit the same. My lord, just now I have received the complaints affidavit, my lord, stating that they have shown the statement of depositing some 50 lakhs. But there was a amount which was about 90 lakhs, which they have withdrawn.
Lords, the apprehension of the complainant is that his pensionary benefits will not be paid. The withdrawal, presently, my lords, we have deposited 50 lakhs. The only direction is to consider the representation. Now this 50 lakhs has been deposited and the documents for having deposited that is produced before this honorable court. My lords, that 50 lakhs is enough for his pensionary benefits, my lords. The representation has been considered positively. The translated copy, my lords, is at Annexure R1, page 19 of the compliance affidavit. The endorsement also says that retirement benefits will be paid by the authority, my lords. His superannuation is on 31/3/2027.
31/3/27.
Please. Page 19.
So where is the representation considered 23rd January?
Plus, that is the endorsement, my lords, considering the representation.
D1.
Lords,
Page 57.
page 19, my lords. 19 of the
My lord, R1 of
R1.
the compliance affidavit which they have filed.
It's page 19, my lord, 6/5/2024 dated.
It's expired.
My lord, it appears that it is filed on 30th/5/2024 by the accused.
Can I give a copy?
What is this?
Lords, the page 19, my lords, is the endorsement given to their representation. R1, annexure R1. Six, 5/2024.
So what is to be done? Complaint.
Lords, it's complied, my lords. We have considered their representation and 50 lakhs has been deposited, which is sufficient for their pensionary benefits.
Your lordship, may I submit? My lord, as pointed out by the accused, that he is superannuating on 31st/3/2027. The apprehension of the complainant was after his retirement, he may not be in a position to receive the funds because it was all drawn. Now they're saying that it is deposited, and taking the that submission, my lord, it may be dropped, my lord. My lord, can there be a detailed order, my lord, because they have.
Detailed order, Ravi, like. We thought we leisurely pass. Heard learned advocate, so and so for the petitioner and learned additional. Government advocate, going to promote the education. It is in respect of the direction issued by Learned Single Judge in order dated 6th July 23. While disposing of the petition, that the contempt of court, that the jurisdiction under the Contempt of Court Act, Courts Act 1971 is sought to be invoked. The directions are that, the directions issued by Learned Single Judge were that you paid the amount 90. deposited
50 lakhs has been deposited, my lords, which is sufficient for their pensionary benefits.
What is this 90 lakhs?
That is only their that is the amount which has been withdrawn. But the direction is to consider their representation, my lords.
Are you satisfied?
Yes, your lordship, but only the thing is, now they have deposited. I am attaining superannuation only on 31st/3/2027. During that period, again, if they withdraw the same amount, so regarding that,
It is their apprehension, my lords, there cannot be.
no, my lord, my only submission is kindly take a note of this R1, it may be disposed of, my lord.
Apprehension, my lords, it is.
Not apprehension, so far they have done the same thing. My lord, kindly taking note of the R1, it may be dropped.
What is R?
R1, page 19 of the compliance affidavit, my lords.
And also 50 lakhs.
Yes,
50 lakhs are
it's been deposited.
40 lakhs का है?
My lords. My lords, this amount is sufficient for their retirement benefits, my lords.
It's a look. Something. Directions which were brought under the contempt jurisdiction as contained in order dated 6th July 23 of Learned Single Judge. Disposing of the petition were as under paragraph 5, page 46. In response to the contempt petition, compliance have been filed. It is stated that the representation of the petition is cited. Furthermore, endorsement dated 6/5/24. Duplicate copy at page 19 and XR was produced. Wherein it is stated that the Urban Development Authority is deposited rupees 50 lakhs in the employees' pension bank account. This amount is relatable to the amount which was to be redeposited by respondent to towards pension.
No, my lords, it is there. He is not yet retired. He is retiring only in 2027. He want that funds to be there so that his retirement benefits will not be affected.
50 lakhs, authority deposited 50 lakhs in the employees, in the bank account of the, in the pension bank account of the petitioner. Thereof. Learned advocate for the petition stated that the petitioner is satisfied with the same. Therefore, the contempt petition does not survive. It is accordingly disposed of.
I'm grateful by one submission, Mayor. Lords, this is not his pension amount, my lords. This is corpus fund. He is not yet retired. It is only on apprehension he's filed a writ petition, my lords.
Amount.
It's not yet due for payment. He's retiring only in 27.
Paid or not to be paid?
Lords, there is no payment due as of now, my lords.
It is only deposited.
He wants it to be in the corpus fund of the department so that he will not be affected. Tomorrow when he retires,
Then you have transferred it to which account?
lords, this authority is not financially sound. There was some.
So we gave a representation. On retirement, respondent number 2 will not be able to fulfill my.
So 50 lakhs is deposited,
It's deposited, my lords.
right? Only deposited, not paid.
Yes.
Deposited. Account of respondent number 2, sir.
Deposited in that pension, in the account of respondent too.
Please. Great, please.
In the account of,
Number 2,
in the account of the Commissioner KGF Urban Development Authority, Kolar District.
respondent number 2 in the writ petition.
Please.
Deposited in the account of respondent number 2 in the writ
Urban Development Authority minutes, please.
Pass over matter, seal number 69. Dhananjay Kumar.
Yes. I may be permitted to withdraw. Permitted to withdraw.
Learned advocate. Okay. What is your name?
My Dhananjay Kumar. The counsel for the petition is Dhananjay Kumar.
Ananjay. Learned advocate. Your name.
Your name.
My name is Arjun. Arjun Eskurup.
Appearing for learned advocate. Memo of withdrawal. Signed by learned advocate Ananjay Kumar. Memo of withdrawal dated 28/1/20. Signed by learned advocate for the petition Ananjay Kumar. Same is taken on record. New York memo, wherein the permission to withdraw is placed. From additional stage withdraw. Petitioner is
Yes. Number 41, Mr. Sudhindra SCA.
For the complainant in this matter.
For the complainant in
this matter.
There was a direction, my lords, on 3/6/2024 to communicate to the private respondent who was a party in the writ petition so that they would be impleaded, my lords, which has been done, my lords, and accordingly the compliance has been filed to that extent, my lords.
Accused number 3 not filed any reply in this matter. Accused number 3 not filed any reply.
Yes, they have to file, my lords. The institution, my lords.
18th March.
My lord, I appear for the accused number 3 in this matter. My lord, I appear for the accused number 3.
Still number 42, Anil Ramchandra.
Lord, I'm for the complainant, my lord.
Accused is present here.
My lord, in the GNWC proceeding, there was an interim order whereby visitation rights through phone call or video call on every Thursday and Saturday was awarded, my lord. It is annexure A, my lord, the order. It is at page number 21. My lord, the operative portion is at page 23, my lord. My lord, if I may just read the operative portion, my lord. Lord, it says pending disposal of IA number 2, the petitioner is permitted to contact his both children on every Thursday and Sunday between 7 to 8 p.m. through phone call, video call until further orders. The respondent shall accommodate the petitioner to exercise the above rights smoothly and regularly. She should encourage the wards to keep in touch with the petitioner so that the bondage between father and children will be developed and there will be a lot of change in lifestyle of the wards. Issue necessary directions to respondent number 2 along with notice on IA, main petition, PF, so on and so forth, my lord. But subsequently they have appeared, but still not complied, my lord. The matter was listed even on 22nd of this month. They are not making, and it is now listed on the 14th, my lord. And 14th identically is the petitioner's, the complainant's son's birthday also. So he is actually pretty much agreed, my lord. The fact of the matter remains that GNWC still needs to be decided, but he is a biological father, which has been observed in the order and appreciated as well.
No issues for the visiting rights, because there are 2 times is going to our house. The accused is present. Accused 2 times present in before honorable court in children's.
My lord, the order is for through phone and video call every week, 2 times a week, my lord. That is not being complied with. And on one occasion, when the family judge asked the respondent in that JWNC case to bring the children, that was the only occasion on which they voted and they didn't allow to speak either. There's a lot of hostility, my lord, and they have not given, in fact, they have not filed any compliance affidavit also now stating compliance, and they are not saying that they have permitted the complainant to speak to the his children. They just keep saying that
affidavit, we obey the court order. You obey the court order, comply the court order.
Complying with the video calls are conducted.
Because when the left the matrimonial home, the accused when the left the matrimonial home, that time blocked this contact. Her husband contacts is blacked. That's
Complying with the direction or not, facilitating the father to talk with the children or not.
no, my lord, they have not complied.
we complied. Complied.
How will you comply?
Here.
How will you comply with?
Because we visiting rights
How will you comply with the direction? That is the
with
question.
video conference mo.
When?
Every Thursday or Sunday. Every Thursday or Sunday.
Now when? Now on what date? Now on what date?
Yes, sir.
Comply with.
Yes, sir.
Which date? Which day we will comply with?
Any date, your Sunday or
You tell the
any
date,
Sunday.
not any date. We are not going to fix your date.
Just
So now you must know how to conduct the matter before the High Court, Mr. Counsel. We are not going to ask every now and then the question and solicit the information. You must make clear your stand. When you are going to comply with, how you are going to comply with, and how you are purging the contempt.
Any Sunday.
Any
Any Sunday. Any Sunday we comply that.
The direction is for 2 days.
Yes, sir.
So when you are going to comply with next?
Next Thursday and Sunday.
Learned advocate Ms. So and so, with reference to the directions which are brought under contempt, states upon instructions of the respondent who is stated to be present in the court personally, that the video call will be arranged on this Thursday, that is 30th January. At what time?
7 o'clock.
At 7
7 p.m.
At 7 p.m. Wherein the petitioner will be permitted to talk to, what is the age of the children?
Now evidence stage. Evidence.
What is the age of the children?
13 years old. You are.
Child or female child?
Male or female, both children.
one male and one
male, 10 years old.
2 children who are, what is the name?
Lord, female is Kripa Asrani and male is Devashish.
Shifa Asrani and Devashish.
Devashish.
The video call meeting may last till the children want to talk to the father.
Yes.
Full stop. The respondents shall produce, the counsel for the respondents will produce. Full stop. To be listed on. First, to be listed on the same exercise shall be undertaken on the next.
Yes.
Saturday, next Sunday, that is 2nd of February.
Yes, madam.
Full stop. The contempt petitions will be next listed on 5th of.
Number 43, so Shrikant VK.
If you, I appear for accused 5 and 6.
Your Lordship.
May
for
not
complaint
survive
this case.
consideration.
On submission, Your Lordship, accused number 4, 5, and 6 has not filed their reply. So accused number 4, 5, and 6 has not filed their reply. So Your Lordship may kindly take it as nil. And accused number 1 is showing that addressee not found. Since accused number 2 represented A1 in the petition 15170, Your Lordship may kindly direct accused number 2 to direct to represent the A1.
I appear for 5 and 6. Contempt is alleged as against an interim order. The underlying proceedings have since attained finality. Therefore, the contempt petition will not survive. My Lord may please have page 116, which is the order of against which contempt is alleged. At 121, the learned single judge, my Lord, remands the matter to the trial court for consideration and says that an order of status quo will continue to be in force until the learned trial court disposes of the application.
And how does it survive?
It does not survive because ultimately the plaint comes to be rejected and the suit is therefore.
And the status quo is ordered.
That's right. That's right.
So that will substitute the order in a contempt.
That's right. At page 122, my Lord has the order returning the plaint. The trial court returns the plaint for want of jurisdiction.
Your Lordship, once the plaint got returned, immediately I challenged before this honorable court. And in the, while this learned single judge, while passing the order, final order, he told during the pendency of the aforesaid applications, the interim order will stand continue. So till the disposal of this OS 2/77, this interim order continues, your lordship. So there's no bar for that. Moreover, the core matter of this contempt petition is, your lordship, once the trial court gave temporary injunction order, by holding that, they took the advanced check. The learned trial court told, don't remove any of the assets, but they took advanced check for the sale of those assets. Once they took that advanced check, your lordship, they came and filed writ petition at this honorable court with mala fide intention, and they gave undertaking that they don't intend to remove any of the assets. But immediately, your lordship, they started to sell all the machineries, all the units, even before the disposal of this writ petition. Your lordship may kindly see annexure T at page number 166, your lordship. Page number 166, annexure T of my rejoinder affidavit. It's in my rejoinder affidavit. In this, your lordship, para number 3.
Yes, which?
166. 166, para 3. Your lordship, permit me to read this para 3, your lordship. Witness volunteers that since the defendants have changed the IPs after submission of their resignation, we decided to file this suit. It is false to suggest that the motive behind filing of the suit is the suit filed by the defendants in OS number 277 of 21. As on 19/8/2021, the plaintiff's company was still running with about 110 workers. When I joined plaintiff's company, there were about 90 employees working. We did not have any intention or motive to remove the assets and machinery equipments from the plaintiff premises. Now all the operations stand straight as on today. The plaintiff's company is also having one more premises wherein also no work is in progress. I do not know what happened to the machinery and other equipments of the plaintiff's company. So they are only deposing that they don't know where are these machineries. And your lordship, at this time, still OS number 277 was pending. Well, it was pending still before trial court. And the temporary injunction order granted by that trial court was still in concern. Meanwhile, your lordship, immediately after the temporary injunction order was given, they started removing, and with mala fide intention, they approached this court and gave completely concealed the facts about receiving the advance check, and they obtained interim order by misleading this court. And further, your lordship, I request you to kindly see annexure W. Annexure W, that is the affidavit given by the workers of their company. It clearly states that once the interim order was passed, they lifted all the machineries. By giving undertaking, they lifted all the machineries, your lordship. Again, annexure H, your lordship. This is NCR. It's in page number 60, your lordship. NCR. Once I came to know that these machineries are being moved or destroyed, I went to police station, jurisdictional police station, and gave complaint. These people, even though the petition is pending before Honorable High Court, they are removing this. And NCR may be seen. Your lordship, and even annexure V, your lordship, have submitted how they have transported all these machineries. Totally, while during the pendency of this petition and during the pendency of this OS, the interim order was still in continue. Meanwhile, they have violated their own undertaking, stating that they won't intend to remove any of the assets. One more thing, your lordship, they only filed an application before this honorable court seeking leave to remove these assets. Once the honorable court disposed of the petition, they immediately disposed all the assets.
That's all. Admittedly, the order brought under the contempt jurisdiction dated 19/8/2021 is an interim order passed in the pending writ petition number 15170 of 2021. Full stop. The said petition now came to be disposed of finally as per judgment and order dated 10th July 2023, copy of which figures on the record of the present content proceedings. Full stop. By the said final order, the case is remanded to the trial court.
Yes,
for deciding afresh. The court has not expressed any opinion on merits. Further, it is directed that that until the applications are disposed of, the interim order dated 19/8/28 shall continue to operate with party. In the aforesaid view, the contempt petition does not survive. It is
Lord, in
dismissed
fact,
as
the
per-
suit is also disposed of
Disposed of.
at
My
page
lord has the motive.
122.
Not only that, the suit is also disposed of.
Please.
Yes, my lord.
In the above view, the contempt petition does not survive. It is dismissed.
Great.
Does not survive. It does not survive as the plaintiff is written.
Returning the plaint. Suit is disposed of by returning
It
the
is
plaint.
returning the plaint.
By
The plaint
returning-
was returned and it was challenged before this honorable court and it's still pending.
They are not presented a fresh claim.
Number 44. Kempe order.
Number 140. Yes, above it.
Matters are connected. Tentatively, my lords have fixed March 6th. This is the pro rata beneficiary capital contribution, BWS.
There are two aspects in this matter. When I applied for NOs,
March 6th, my lords have tentatively fixed it. Subject to my lords what Learned Senior Counsel.
I have only one submission to make. Learned single judge misdirects advance pro rata charges to the pro rata charges. Pro rata charges, my lords, under the water supply regulations, I have to pay at the rate specified when I am applying for water supply connection after construction is over and after occupancy certificate is issued. I have no quarrel with that. When I applied for the NOC for applying to BBMP for building license sanction, BWSSB issues me a demand note, which contains NOC fee on which I cannot have any grievance. Then, my lords, advance pro rata charges. Advance pro rata charges is something that is not permitted, that is not even defined, nor permissible under the regulations. Learned single judge holding that earlier in Munswami's case, pro rata charges have been approved by this court. He sanctifies the advance pro rata charges demand. Therefore, my lords, my grievance right now is, my lords, this advance pro rata charges required to be stayed is my respective submission. Advance pro rata charges required to be another.
May I answer? May I answer? I'll come to that. That's pro rata, please, my lords, is 100% what they charge. At the stage of initiation of construction, please, my lords, we will not know what they will construct. So at that stage, please, my lords, we will charge them only 15%.
No, in other connected appeals, any interim order is passed.
But I have filed an appeal, please, my lords, because beneficiary capital
There is
contribution,
some interim order is passed.
some interim order is passed.
To find out.
Please, my lords. And that
Or-
was certain, I think,
or-
50%, my lords, it has been ordered. 50% of what has been
Yet the-
demanded. Yes.
Madam, formally direct notice is not
There
ordered.
is- I will take notice, my lords, for the respondents.
Notice is not issued.
Notice is not ordered yet.
Returnable on them.
There is an office note regarding memo. Memo is only, I have placed the main judgment on record. Because in the appeal, I have questioned only the
3 and
following.
4, I
fact.
take notice.
6th of March.
3 and 4, my lords, I will take.
I'll take notice for 1 and 2.
5
1 and 2
4,
state.
3 and
3 and 4.
1 and 2 am available.
Whereas learned, additional government.
Huh?
Except for 1 and
1 and 2.
then 2.
MN Pawan Kumar may be directed to take notice for respondent 5 BBM.
Let's say 5 have appeared up.
It's appeared already. BBM.
Yes, have appeared. 5 for R5. 3
Three
and
and
4, I
four.
will take notice.
BW. Number 45, Mr. Vinay, H.
office officer shall be complied with within 3 weeks, failing which the appeal shall stand automatically dismissed without reference to a order of the court. Next, 46.
Number 46.
Awaiting service. Service is awaited to be posted after all the respondents are served.
Number 47. 47 Furnishing of and, free exit. R2 and R3 service, we have taken steps, my lord.
This is
R1, we have served a copy, my lord.
service is awaited in
For
respect
R2
of
and R.
one and respondent two to be listed after the service is complete.
Grateful.
Here for the complainant petitioner in TCC 340.
You can take note.
We'll go together.
Take one, my.
Please.
And for,
So, copy.
I myself respond one, my lord.
And
I'm
we
the
have to
accused
serve
party.
government.
I undertake
You
to
have
buy
to
the
serve.
wakalat
In the list of.
at the earliest, my lord. This for the pensionary benefits, my lord.
Much of. What is 48? There are steps. 48 will take, we'll do the needful.
Nobody is.
State appeal, my lord, I will take steps, my lord. State appeal, my lord, we will do the needful. A week's time. So, number 49, Mr. Anand K.
Appointment, 2 weeks, minutes, we will take steps.
2 weeks is granted to office, no, the official is prayed for, failing which. Usual. Yes, next.
So 50 is urgent. 51, office objection for second time. Mr. Muralidhar HM.
3 weeks time is granted, failing which. 4 weeks, second time, 4 weeks time is granted.
For third time, number 52, Mr. Rajendra Kumar Shingre.
Lord, sorry, appear for the appellant in serial number
Sorry.
52.2.
52.2.
52.2.
Sorry.
In all 50.
1 week time may be granted, my lords, so that.
4 weeks time. Next,
Number 53, Mr. Bhaskar CR.
in 4 weeks is granted. Failing which the contempt petition. Yes, next.
54 is urgent. Number 55 for
3
fifth
weeks
time.
is granted.
56.
Not 3 weeks, 2 weeks, 55. Failing which the appeal will send this.
For 9 times, number 56.
56, 2 weeks is granted. Same order.
So council submission, number 57, Mr. Subramania R. Subramania R.
Yes.
Well, it's, I will produce the documents, my lord. Translated copy I will produce, my lord.
Learned advocate Mr. Subramaniam R stated that the translation copy will be produced within 2 weeks. Once the translation copy is produced, the registry is will list the appeal.
Number 58, Mr. TP Muttana.
My lord, respondent number 2,
58.
who is assistant general manager has filed this appeal, my lord. Number 1 is manager. Assistant general manager filed on behalf of manager and assistant general manager. This objection may kindly be overruled, my lord. Now that office says that both the
Office objection overruled. Next.
59 is urgent. Number 60, this objection with council submission. With the Manisha Kangovi.
3 weeks time is granted to remove the office objection. Failing which the appeal shall automatically. He's not there. Anyway, so give some date.
One submission.
18th March. None present.
Serial number 60, my. Serial number 60.
60, you are there.
I am for the appellant, serial number 60.
Oh.
In that case, I made submission, Your Honor. These are legible copies are produced. Only for reference of NOC applications are filed. We are not relying upon the said document. That may be overruled and notice may be issued, Your Honor. There is a delay of 16 days in filing the
So
appeal.
objection regarding what? Regarding production of
A legible copy of the annexure H, Your Honor,
legible.
filed before
copy
the learned single.
is dispensed with. Inasmuch as the will bring.
Please, Your
Why it is dispensed with?
Lordship, you are not referring to that document. There's a role NOC obtained.
Since counsel petitioner will not rely on the same.
Please.
Number 61.
There's a delay of 16 days. Notice may be issued.
16 days notice. 60 notice it on 18th March.
Number 61.
But the present appeal has 515 days of delay, my lords. We had filed a review petition, my lords. In this, we are challenging the impugned order of 13/2/2023, my lords. There is an error apparent in this, my lords. At the time of
No,
superannuation,
where are the office objections?
my lords, the office objections are 2 pages which tells it is not legible, my lords, but those are the documents where we got it from the other side, my lords.
Then you
We are not
read it.
relying over it, my lords.
Unless
It
unless the office objection is removed within 2 weeks, the appeal shall automatically stand dismissed without reference to our order.
My lords, a week's time may be given, my lords.
3 weeks is granted. Shah.
Please.
Next.
62 urgent, number 63.
Appearing for appellant, my lords.
Ramesh.
My lords, the instructions are that to withdraw the appeal, my lords. I'll be filing memo with that aspect, my lords, in the next date of hearing.
Order is already been issued in favor of the respondent number 3. Under the section 16 of the KTPP Act, there is a provision for the appeal. The appellant have a provision for go for the appeal matter.
Provision for?
Section 16 matter, KTPP Act.
There is work order issued, my lords.
Section 16 of KTPP Act, my lord.
What is that?
My lord, there is the work order has been issued. They've challenged the tender notification, my lord. The interim order is vacated by the single judge, my lord, in the WP.
So
And
withdraw-
24/9/2024, the work order has been issued.
Respondent. So it will not survive.
Yes, ma'am.
Who is appellant?
I am the
Rohit
appellant. my
Ramesh.
lord. I am
63.
appearing for the appellant.
Advocate, Ms. Swansea. You are there? Yes, Mr.
Yes, my lords, the work order has
Sir,
been
you are
issued.
not audible, sir. 63.
My lords, am I audible, my lords?
Ramesh.
My lords,
Not audible
You are
still.
not audible, sir.
Muted. No.
my lords, am I audible, my lords?
Our video is also muted. Our audio, video is also muted there.
Are you able to hear us?
I am able to hear us, my lords. I am able to hear
But
us.
we are not able to hear you.
My lords, am I audible now, my lords?
So now you are able to hear us or not?
I am able to hear you,
Then
my lords.
you are not audible then. We are audible, you are not able. The counsel of the other side has filed a memo which says that the respondent on 3 and 4 here it produces the government order dated 24/9/24 for the perusal of the court. Hence the memo may be taken on record. What is the government order?
Regarding the work order, my lord. The
Work
work
order is
issued the
given,
work
so
order in favor.
It will not survive. Correct?
Yes, my lords.
Yes. Same. In that view. The appeal will not survive. Learned advocate, Mr. So appearing for appellant. The video conferencing could not dispute the aforesaid proposition. Accordingly, appeal is disposed of as not surviving.
This is number 64, Mr. K. Abhinavanan.
Disposed. 63.
63.
Third respondent, my lords, had, along with their objections, had filed certain documents. Those documents were not referred to as annexures. They had simply filed along with the statement of objections. And those documents are filed in the appeal at page 106 to 117, my lord. And as the objects, these documents are not referred to as annexures, office has raised the objections. And if those documents are unwanted, I will remove those documents, my lord.
To produce the Xerox copies.
I have produced the copies, my lord. I have produced the copies at page 106 to 117. The office has raised the objection, clarify these documents because they were not having any reference of annexures.
They're lying in appeal.
They were not having any reference of objections filed along with the objections of R3.
File. You file subsequent. You file subsequently.
No, my lord, along with the main appeal only we had filed, those documents filed by the third respondent along with their objections were not having any reference as annexures. And those documents the office wanted to clarify. I've made submissions stating that those documents filed by R3 along with the objections were not having any annexure reference. And as it is, I have produced. That was my explanation, my lords.
Not able to understand anything. What is said? What is said?
My lord, page number 106
At 6 to
117, my lord, he says it's part of the writ petition, but not marked as annexure in the writ petition. Therefore, the registry has raised an objection that there is no marking of annexure. So that is his submission.
Mark it and remove.
That was not
in the
marked by the
petition.
respondent in the writ petition, my lord.
So say not marked. Mark in that way. You can write on the top that not marked.
Please,
Accordingly, it is marked.
please, please, please. Please.
So next.
A lot's date may be given in this matter, madam.
Which date? After the office officer is removed, the appeal shall be listed on 10th February.
Number 65, Mr. Sachin BS.
My lords, in this matter, I am appearing for the appellant. The council submission is that, my lords, annexure L2, annexure O, my lords, there are the color photos, my lords, which was produced by the petitioner before the learned single judge. Now, my lords, I have produced the black and white photographs, my lords, because I couldn't.
Office objection regarding color, production of color photographs is dispensed with.
Much older.
Since
My lords.
the photographs in black and white are produced.
My lords, petitioners are subsequent purchasers. My lords, these are
The
matter.
appeal may be listed on 13th. There is a delay, will issue notice. Delay of 974 days,
Yes.
delay. In delay, delay condonation, notice returnable on 18th, 25th February.
Much.
This final hearing matter, Chamber 66, Prakash T. Ebbar.
Lords, I appear in 66.2. Lord, 66.2 is actually a private matter where, my lords, we have challenged a circular issued by the state government prescribing the mode of calculation of stamp duty on joint development agreements. Now, my lords, 66, which is a PAL, my lords, our matter is tagged on with the PAL. So what's happening is, though we are praying for an interim order, it's tagged with this, and there is no statement of objections being filed in 66.2. PAL, my lords, we are not sure how it's maintainable because it's only people for whom, my lords, we are interested in registering the properties. So 66.2 has got tagged with the PAL, though we are not parties, we do not know the subject matter of the PAL. my lord.
For petitioner in serial number 66. I request 1 week to address the argument. But there is no objection to deduct the.
Appear for petitioner in 66.1.
Same. ಯಾವ ನೋಟಿಫಿಕೇಶನ್ ಕೇಳಿದ್ರು ಮಷೀನ್ 66.2 ಸೇಮ್ ಅದನ್ನೇ PAL appears they have challenged the same circular in 66.2, the impugned circular, your lordship, get at page, annexure A page. It's in Kannada, of course. That's unfortunately in 66.2, the impugned circular which we have challenged is in Kannada, which appears to have been challenged in a PIL. That's my lords directing the government on the basis how to calculate stamp duty for a joint development agreement. We are challenging that because we are agreed privately. Now in a PIL, my lords, of course, we will not come in the way, but our matter has got tagged with the PIL and they have not even filed a counter in our matters.
PL should, why should it take this matter?
My lords,
Same notification is challenged.
in a PIL.
Take upon somewhere in February 24.
In the meanwhile, if the government, because my lords, we are having an urgency, we had sought for a stay, but the government before the learned single judge submitted, there is a PIL pending and it's been posted here. So my
And the
lords, they are
PL matter
enforcing.
Objections have been filed, I believe, my lord. If it is delinked, my lord, it will go before the learned single judge, but the circular that has been challenged is the same. Therefore, my lord, if the main matter is decided, my lord, that will.
In the meanwhile, they are
binding in the
charging us.
Must be placed together by some judicial order.
By,
It's by a judicial order because the government had made a submission.
the
before
same
learned.
notification is is impugned in the PIL also.
So on that they will take.
Whatever is decided in the 66, my lord, serial number 1, that will follow for the connected petition as well, my lord.
Unfortunately, we are seeking for an interim order because, my lords, that's being enforced on us and we have to pay stamp duty on a joint development agreement as if it's a sale deal. The Stamp Act says otherwise. That's why, more I don't want the government to say that they have not filed a counter and.
We'll file in the connected writ petition also.
Filed it?
We'll file it in the connected writ petition also, my lord.
Filed or
Objections.
not filed?
So far, we have not filed. We'll file it, my lord.
Before next date you do so that.
So that the pleadings are complete, my lord, in the writ petition also.
Please.
Interim order.
Interim order.
Interim order shall continue if it is granted. If it is there.
So, my lord, if interim order is there, my lord, that will be applicable to the writ petitioners also.
For us, we are.
How come interim order is passed at the stage of interim removal of office?
There is no interim order in 66.1, my lord. There is no.
We also do not have because our matters got tagged here. We are not. If it's an interim order, my lords, we should also be extended that benefit in 66.1 and 2. It's not the time.
It's not there, sir.
There is no.
10/4/23 it was extended. 10/4/2023 it was extended, madam, since the matter didn't reach up.
It is not extended.
So granted when? Only notice.
No, by mistake, once it has been ordered that interim order, if any, is extended till next date of hearing, that's all. But there is no interim order. On 13/3/23, interim order, if any, to continue till next date, it was ordered. But there is no interim order.
Apologize. Sorry.
In fact, in 66.1, my lord, the state has filed objections to the IA for stay before the learned single judge, and thereafter, my lord, the matter was set before this honorable court. And there I have also filed translation, my lord, of the Kannada.
Very good.
Please.
Number 67. To Vilas Ranganath Datta.
Government, this will have far-reaching implications in terms of revenue to the state.
Please, my lord.
You'll have to take it seriously.
Madam Nilofer appears in this PI
No,
matter, my
whatever.
lord. I am short of instructions here. We'll attend to that.
Lord, in this matter, may I seek a week's accommodation, my lord, to compilation of the judgments? This is a fixed term employment in the standing orders that has been incorporated, which is before your lordship challenged. I'm seeking some accommodation, my lord. Please. Grateful, my lord.